For attention item 1.
May it please your worship. My lord, I am before this honorable court because of the order dated 18/2/22.
Eighteen to 22 passed in which case?
In WPC 1057 of 2022. Assam Land and Revenue Regulation shall control. Ravi.
Why this matter is before the
My
division?
lord, I have formulated 3 questions. My lord. Because same coordinate bench, while deciding 18(2) of rule 18(2) of Assam Land and Revenue Regulation. One is of 2006 3 GLR page 99 and another is 2018 1 GLR page 30.
Where is that? 2018 1 GLR? Where is that judgment?
My lord, that judgment, my lord, because here the printout is not available. I've given a list of books.
2018 judgment is authored by?
My lord, Justice A.M. Bujulburu.
What has been held there?
My lord, that in 18(2) notice has to be issued before ejectment. And in earlier judgment 2006 3 GLR page 99 says there is no need because rule 16 says a person does not acquire any right until unless he acquires a lease or something from the government.
So is there another judgment? of-
2006 3 GLR page 99.
By one of us, where it has been held that it is not required to issue notice? You are not aware.
Yes, madam, I am aware.
Where is the judgment?
My lord, in the issues I have laid down that judgment.
That my lord will find it 2018 1 GLR.
No,
Now,
2006 3 GLR page 99.
Oh, Mr. Roy, please hold your guns.
My lord.
One of us has authored a judgment where this view has been expressed. You want this bench to hear the matter.
My lord, no, my lord, no, but here last occasion.
One of us has authored a judgment where it has been held that no notice is required. We'll go by that view.
Not authored, my lord, one of the, my lord. Oh,
Where is the judgment, Mr. Bapujari? Nobody is aware. You are also not aware.
madam, no, we will be, madam, here is a case. Lordship judgment is there in Taher Ali. Lordship will perhaps recollect. Lordship sitting singly was deciding that that's
Where is the judgment of
Yes.
Tahir Ali? Have you read the judgment in Tahir Ali?
but I have not seen.
That's what we are asking you.
You got a copy?
Please read para 15 of the judgment.
My lord, it is.
Those were the cases pertaining to eviction, my lord, drive, my lord, undertaken by the district administration in the Chor areas in Sonitpur district.
But the issue is whether notice under rule 18(2) is required.
No, there, in that decision, my lord has said that although notice is not required, but since we are a state, and my lord, the rules of prudence require that notice may be issued. But Lordship has not per se indicated that that direction as a positive, in a positive way, but nonetheless, Lordship has expressed an opinion that my lord will find in that decision. Lordship may kindly, Lordship may kindly come to para 20 of that decision, my lord. Lordship may kindly come to para 20 and 21. I am reading it, my lord. No person can claim to have an indefeasible right either to encroach upon or to continue in unauthorized occupation of any government land. Therefore, when a process of eviction of encroachers is initiated by following the due process of law, the writ court cannot interdict in such process so as to protect illegal occupation of encroachers upon government land. What would, however, be significant to note herein is that regardless of the provisions contained in the settlement rules, principles of ode alteram partem rule must be complied with in all cases involving removal of encroachment from government land, so as to give a reasonable opportunity to the unauthorized occupants to vacate the land under their possession. In the present case, the respondents have admittedly complied with the rules of ode alteram partem by serving notices upon the petitioners. For the reasons stated herein before, I am of the view that no case for interference with the eviction notices has been made out. These writ petitions are therefore held to be devoid of any merit. However, taking note of the submissions of the petitioners' counsel that their clients have been in occupation of the khas land since more than 30 years, for the ends of justice, the petitioners are granted time till 30/11/2019 to vacate the government land under their occupation by removing the structures standing thereupon. It is made clear that if the petitioners fail to voluntarily hand over vacant possession of the land to the concerned circle officer on or before 30/11/2019, the respondents would be at liberty to take appropriate action in the matter and evict the petitioners from the circular land under their occupation without serving any further notice. Here, my lord, prior to issuing these directions in paragraph 20 and 21, Lordship has extensively dealt with, my lord, the dictum of this honorable court, my lord, pronounced in the case of Kundargaon Anti-Eviction Committee. Now, as of now, my lord, with regard to Silsaku Bill eviction matters, my lord, the judgment has come from the coordinate bench.
So Mr. Rajendra will hear,
My
will
lord.
hear you. Let us try to understand
My
what
lord,
is the dimension here.
In fact, here, my lord, the coordinate bench, my lord, I'm sorry, my lord, the learned single judge, my lord, has dealt with both Kundargaon Anti-Eviction Committee as well as my lord Bimal Das, and came to the conclusion that Rule 18(2) prescribes that no notice, my lord, ipso facto is required in a matter of, my lord, carrying out eviction by the district authorities, revenue authorities. And Rule 18(2) was also, my lord, put to challenge before the Honorable Division Bench, my lord. That has also been negated. Everything has been discussed in this judgment, my lord. Rupjyoti Bora Borgohain, my lord, this pertains to, my lord, the recent eviction process carried out by the district administration, my lord, over the Silsaku area, so as to prevent waterlogging, my lord, in the greater area of Guwahati city. This is how, my lord, the
My
court has
lord,
dealt with.
here the reference is whether notice is required to be given or not. 2006 dealt with, that Kundargaon dealt with that nothing, no notice should be given. Rule 16 says illegal encroachers, they should be forthright taken away. Here, my lord, subsequent judgment came 18-1, that notice has to be given. Then your lordship's judgment is there, the notice audio alternate partem rule, because statute may be silent, still then something has to be provided. So, my lord, some condition, some notice for 15 days was given by your lordship. Now, another single bench has decided that no, illegal appointments, illegal encroachers, so no notice to be given, it should be outright thrown away. So a division bench should formulate that.
All right, now please tell us one thing.
My lord.
The judgment authored by me in the case of Taher Ali,
My lord.
at least expresses clear opinion that 18-2 notice is not required.
Not required.
Now, if that is an issue in this petition, then we cannot, this bench cannot hear the matter.
No, this bench cannot hear that.
As your lordship desires, because I have to make it clear, because this. My lord, when this matter was decided by Honorable Mr. Justice Sanjay Medhi in this Silsako eviction matter, my lord, the fact that this matter, Salakuddin, presently is pending before the division bench, that was also put to the notice before the Honorable Court. And the fact that, my lord, there are two decisions, my lord, that Bimal Das say that no notice has to be there, and Kundargaon says that no notice is required. Everything has been dealt with by, my lord, by the Honorable Single Judge.
All are the coordinate benches. So, my lord, there should be single judges. So there should be a judgment from the larger bench. So whether notice is required or at all notice is not required. Three different judgments are there.
Otherwise, lordship may.
Not be proper for this bench to hear the
My
matter.
lord, my lord.
Take down. Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr. R.C. Borpujari, learned standing counsel, Revenue Department, Assam, as well as, you are appearing for all the respondents,
My lord.
appearing for the respondents. This writ petition has been listed before the specially constituted division bench on the strength of the order dated. Order dated 14/6/2023 of the Honorable Chief Justice issued in the administrative side so as to administrative side. The central issue involved in this writ petition is pertaining to Rule 18(2) of the settlement rules. Full stop. While interpreting the rules, Rule 18(2), the learned single judges have expressed the opinion that there is no requirement for issuance of notice under Rule 18 sub-rule 2 before evicting encroachers over government khas land. However, in the judgment and order passed by the learned single judge in, which is the case?
My lord.
Divergent view. Learned single judge in the case of-
Page 30.
Sorry,
2018 1 GLR page 30.
in the case of so-and-so, what is the party's name, please?
My lord, Bimal Chandra Das.
Bimal Chandra Das versus State
State of Assam.
Chandra Das versus State of Assam reported in 2018.
2018 1 GLR page 30.
Page 30.
My lord.
A divergent view has been expressed by the learned single judge by holding that notice under Rule 18 sub-rule 2 of the settlement rules is mandatory even for eviction of encroachers over government khas land. Full stop. In order to settle the law in the backdrop of such divergent views expressed by coordinate benches of this court, this matter was listed before the specially constituted division bench. However, during the course of hearing of this matter, the learned counsel for the parties have invited the attention of this court to the decision rendered in the case of Taher Ali versus State of Assam bracket WPC number 6158 oblique 2019, authored by one of us, bracket my name, wherein an opinion has been expressed on this central issue, thereby holding that notice under Rule 18, Sub-Rule 2 of the settlement rules would not be necessary before evicting encroachers over government caste land. In the decision of Tahir Ali, bracket Supra, although it has been mentioned that notwithstanding the fact that notice under Rule 18, Sub-Rule 2 is not necessary, the rules of audi alteram partem has to be followed by the state before carrying out the eviction drive. Yet, since a clear opinion has been expressed by one of us in the case of Tahir Ali governing the issue arising in this writ petition, we are of the view that it would not be proper for this bench to hear the matter. As such, register to place this writ petition before the Honorable Chief Justice for further orders for constituting a bench afresh without one of us, bracket mine.
And so obliged.
May it be the lawsuit. Lord, this is with regard to, Lord, judicial infrastructure and accommodation to the judicial officers. This has come after a long time, Lord, after 6-7 months, Lord. One set of affidavits were filed in the month of July and August, Lord. Perhaps state is required to file some updated affidavit.
Let us go state by state. What is the situation in Assam?
If your lordships kindly take up the affidavit filed by the state of Assam.
Lordship, my last affidavit was filed on 27th of July 2022, Lordship. So definitely since then, Lordship, so many updates have taken place, Lordship.
Then when was the last affidavit filed by Arunachal?
Arunachal, my lord, on 3rd of August 2008. Similar is the situation here. Here works master.
What about Mizoram?
18/7/2022.
And Nagaland?
28/7/2022.
All right. So some updated affidavits are required to be filed.
Maybe after the election.
Ms. Chaudhary, one of the striking issues, you are in item number?
8, Your Lordship, if I'm not mistaken. Today's list, item 8, Your Lordship. Yes, 8. There the
find
issues
that,
are slightly different, Your Lordship.
Yes, issue is slightly different.
Yes,
You are for the women,
not just women, Your Lordship, for under trial prisoners,
Under trial
the cells which are identified for such people
Hmm.
and the facilities which are available to them. It was in fact a taken up matter by the suo motu taken up matter by this honorable court. I'm just assisting this on.
yes, I think some work has, after your,
Some
able
work
assistance.
has, again, Your Lordships, I only have a 2022 communication in my hands, which I think was handed over to me by one of the registry people. But this is also 2022. I had in fact made a chart and submitted before the court on the last occasion when the matter was taken up as to what are the districts where facilities are yet to be provided and what are the facilities which are to be provided. In fact, that chart must be available in Your Lordship's file. It looks something like this, Your Lordships, district like
Yes.
vice facilities,
we will come into that,
Lordships.
but what needs to be mentioned here in that, as we judges go on inspecting new buildings that have been constructed not only in Assam, other parts of the state, we find that on some of the very crucial areas, there is practically no attention bestowed. For example, making disabled people with special ability, for them making approaches which are
Lordships.
friendly for them.
Lordships.
Many other sensitive issues pertaining to women, children, etc.
Lordships.
There is no uniform pattern for the judiciary.
Lordships.
Forget the other branches, where there is a model design which is to be followed in all cases mandatorily. So while appreciating the work you have done for the women under trial prisoners, we were wondering whether we could extend the scope of the PIL in which you are there
Lordships.
to cover even areas such as this,
Lordships.
where we can examine it, and after taking the views of the respective governments, we can lay down some guidelines that in every
yes.
case where a future building plan is prepared, these things will have to be mandatorily be there.
Lordships. In
And we
fact,
can-
to my limited knowledge, Lordships, in the UNCRPD guidelines, the
Hmm.
United Nations Convention on Rights of Persons with Disabilities, there is a thing called universal design, which is required to be followed by all state partners, all stakeholders. I mean, whichever country has signed the UNCRPD, and India being a signatory to it, naturally has to conform to this universal design, which unfortunately is not being done. In fact, if your Lordships may perhaps recall, I was made to travel to Golaghat as part of this particular thing, and the new building which was formulated there.
I hope
Although-
that was not a trouble.
No, it was certainly not any trouble, your Lordships. In fact, it was a very good experience for all of us. But there, what had happened was, your Lordships, that although the rooms and all have been very well made, again, they're not disable friendly, your Lordship. They're with persons with disabilities. The toilet inside the room is not accessible. There's not a ramp. Inside the toilet, there is no handrail for the person with disability to be able to go there. So those small, although the lift is accessible, yes, from the ground floor, but the lift is so small that the wheelchair will not even go in. That was the difficulty which we found. Now, after the building has been constructed, then demolishing and making changes, it becomes very, very difficult. So these are things which should be seen at the inception. When the blueprint of a building is being made, it is at that point of time that these changes
would
ought
you
to
like
be made.
to make some contribution in this regard by coming up with some?
Lordships,
Yes,
I had also annexed another report in the report which I had submitted before this honorable court. This is a court development planning system. This was a report by Justice Badruddin Ahmed, B.R. Ahmed, and it was a national court development planning system report. So that report also, I think this report was placed in
You are right.
2012.
Just a minute.
Yes, Your Lordship.
You see, the problem is these reports are fine, but these reports are usually very elaborate and lengthy. What would be useful for the purpose of this matter
Lordships.
is if you could take out the high points
Absolutely,
in a very, very concise
certainly.
manner and give it to the authorities who are in charge of making the designs and drawings.
Lordships,
This bench will basically perform the task of monitoring
Lordships.
and putting things in places. We are neither going to construct nor going to come up with designs. So you, due to your expertise, will bring in the views of the bar and as well as the people who are in need of this assistance.
Lordships.
And the experts in the government field, they will be able to respond to that. If there is a consensus, we'll go ahead. We'll
Lordships.
formulate a universal design and go ahead. So at the end of the day, we must have models. We must have models for court premises. The models could be plan A, plan B, plan C, depending on various sizes. But it can't be that in every building, everybody will sit and figure out whether this is there, that is there. That is a colossal wastage of time. So once we have the inputs and we come up with a design which can be universally applied, depending on the size of the plot of land, if the land is beyond this size, then this could be the land is of this size. But some features which are essential in every building must be there. So will it be a good idea to begin with coming up with a model?
Lordships, in fact, if I may just point out that the report of Justice B.R. Ahmed, the appendix in that particular report, I have annexed a few of them. If your Lordships will find it, the entire court plan is also addressed how a court building should be made. If your Lordships will find at page 27, 28 of the report, I have placed that report before your Lordships. The entire thing has already been dealt with by that particular committee. All that is required is perhaps for the officials to go through that report and then comply with the directions therein, your Lordship. That is, of course, it is not a mandatory report. It's the first sentence of the report itself says that this is just an advisory thing. So that is perhaps the reason why it's not being taken note of.
All right. The other thing we wanted to ask is, why are so many writ petitions there in this bunch? It's became an unmanageable bundle. Why don't we close all the other matters and transfer the pleadings into one writ petition? That is one item, whichever item is there.
My item, Your Lordship, it is WPC 6424 of 2011.
515873.
Why don't we
Um,
subsume all the issues
Huh,
in item number 2?
Lordship,
Transfer the pleadings
huh,
and only keep item 2 alive
two.
for
Your
decision of all the issues. We'll close the other matters.
Lordship. Yeah, what we can- oh, yes. Two, he's trying to keep item number 2 alive in the way government was saying, this one. Your Lordship is talking about 5373 of 2006.
Yes,
One is
5873.
sales.
Yes, he wants to club all of it, everything into visual infrastructure. Not just main.
Well, otherwise, factually, this petition is slightly different from others. Others deal with normal infrastructure. This is specifically in respect of
Under trial, sales for under trial.
sales for
prisoners.
under trial prisoners. Otherwise, my lord, it comes within the infrastructure again.
So the central issue is developing infrastructure for the judiciary,
Can be.
as well as the residential
Yes.
accommodation
This also ultimately comes
facilities
within
for
the
the-
infrastructure issue, my lord.
facility. We are now in the realm of living in an era where there is a clamor for better facility. Facility has to be there, but it has to be there for everybody,
Yes.
not only for one category of people. So therefore, instead of listing those 8-10 matters every day, why don't we subsume the issues in other
In
matters
one,
into one?
my,
We'll request the registry, we'll ask the registry to segregate the pleadings, come up with paper books for the pleadings so far
yes, ma'am.
with clear titles. And make all councils in the other matters show their names in one item.
Yes.
So that if anybody
That
wants
is
to,
better, possible that will be better.
yes,
Yes,
that will make things a little less cumbrous.
yes, let's come.
Otherwise, searching for which order, which
Yes,
case, which order has been passed. What do you say, Mr. Wilson?
My lord, that is perfectly all right. So far, there are 3 cases shown in this list from Arunachal Pradesh, my lord. Although the matters are not connected to the issue in hand, my lord. Here, what happens, my lord, it involves at certain point of time, my lord, in all the 3 cases, my lord, land that is given to the judiciary for development of the infrastructure for quarters. Only in that connection, those matters have been listed. Otherwise, the issues are different in those cases, but involves land, man, or part of the land that is given to some
Which are
quarter.
those matters?
My lord, six, my lord. 9 and Kangong, and my lord, 10, my lord, Kangong Apang. 6, 9 and 10.
So 6, 9 and 10 will ask them to be segregated and listed.
Yes, my lord, if the registry does this, my lord. If necessary, we can always bring back later, man.
All right, then, when would be a good time to have these matters again?
It'll be after the
As per your
vacation.
Lordship's convenience.
After the
After the
After,
vacation.
after 4 weeks. No, only one aspect I'd like to point out, in item number 2, there is a communication from registry to the LR of Milord March. Lordship will have a look. While filing the updated status report, the state will also include those details, Milord. They will also update, Milord, instruction, give report with regard to those districts, Milord. There is a communication of March 2023, Milord.
Which
Lordship will include in the order,
Orders will also be bunched up into one paper book.
my lord.
So we'll have separate paper books of pleadings, affidavits filed by each state
My lord.
with responses from the amicus curiae. We'll have a paper book of orders passed in all these cases, serially arranged. And we'll have the names of councils of these cases, except item 6, 9, and 10,
Lordship,
shown against item number 2.
yes,
And all issues arising in item number 3, 4, 5, 7, and 8 will stand subsumed
fine.
into one.
and
Into one.
merge into the issues which will be decided in WPC number 5873 of
Fine.
2006,
Fine.
correct? And we will have this matter listed.
Last week of July, maybe last week of July.
Let us have it on 25th of July.
Ah, yeah.
25th of July. So you take down.
Yes, madam.
Heard Mr. H.K. Das, learned amicus curiae appearing in item 2. Also heard
Yeah.
Ms. R.S. Chaudhary, learned amicus curiae appearing in item 3.
Very-
First up, Mr. D. Majumdar, learned additional AG Assam, assisted by Mr. P. Nayak, has appeared for the state of Assam, Mr. B.D. Goswami, learned additional AG Assam for the state of Arunachal Pradesh. Mr. A. Kalita, learned additional AG Mizoram for the state of Mizoram, and Ms. T. Crow, learned additional AG Nagaland for the state of Nagaland. First up. These matters, these read petitions, these bunch of read petitions have been tagged together and posted before this specially constituted infrastructure bench so as to examine and delve into the burning issues of creating adequate infrastructure for the judiciary, both for the court premises as well as the residential accommodation of judicial officers at the district level in all the 4 states. First up, the work done in this regard pursuant to orders passed by this court from time to time in this batch of writ petitions have been brought on record by the respective states by filing their affidavits. First up, we have noticed that the affidavit by the state of Assam was the last affidavit of the state of Assam was filed on 27/7/2022 by the state of Arunachal Pradesh on 3/8/2022, by the state of Mizoram on 18/7/2022, and by the state of Nagaland on 28/7/2022. First up, in between, this matter could not be posted before the bench due to non-availability of the concerned bench. First up, however, the learned additional advocate generals appearing for the respective states have appraised this court that in the meantime, some more developments have taken place, which are required to be brought on record by filing appropriate affidavit, for which 4 weeks' time is necessary. First up. This court has also noticed that construction of judicial court premises is going on in many places within the state of Assam, as well as the 3 other states, namely Arunachal Pradesh, Mizoram, and Nagaland, coming within the jurisdiction of this High Court. However, complaints are often received from the stakeholders indicating that facilities in those court premises are not disabled friendly. Full stop. The manner in which the washrooms and the entry ramp are being constructed in many of the premises bears testimony to the above fact. Differential step. In order to avoid future inconveniences for the differently able persons, and so as to address these issues once and for all by coming up with a comprehensive action plan, this court is of the opinion that the learned amicus curiae, Ms. R.S. Chaudhary, be requested to examine the reports already available on record and place a gist of all recommendations which, according to her, can be incorporated in the drawings and designs of the building as within quotes, universal designs, unquote, so as to address those issues. Full stop. Full stop. We have also noticed that although the central issue involved in all these proceedings, as noticed above, pertains to creation of proper infrastructure for the judiciary. As many as data repetition of 9, as many as 9 read petitions, that is item numbers 2 to 10, have been listed before this court, thereby making it a voluminous collection of papers, full stop. It has been pointed out at the bar that item numbers 6, 9, and 10 projects issues, have issues involved which are not one and the same with the core issue involved in this proceeding. However, since there is an element of controversy pertaining to acquisition of land for the judiciary, those matters have been tagged together in this batch of read petitions. Full stop. It is submitted at the bar that item number 6, 9, and 10 can be segregated and dealt with separately on the merit of each case. Full stop. After taking note of the submissions made by learned counsel for both the parties, we issue the following directions to the registry. Number 1, the only issue that would be dealt with by this specially constituted bench in this matter is the question of creation of proper infrastructure for the judiciary in terms of building of court premises and residential accommodations for the judicial officers and all ancillary issues thereto by providing adequate facility to the stakeholders, including the persons who are differently abled. Full stop. Number 2, the aforesaid issue shall be taken up in WPC number 5873 of 2006. Full stop. Therefore, the case papers connected with item numbers 3, 4, 5, 7, and 8 be transferred to the present petition with a clear understanding that issues, different issues which are involved in those cases shall stand subsumed and merged into the present rate petition. Full stop. Merge into WPC number 5873 of 2006. Next, registry to prepare separate volumes of all the pleadings filed by the 4 states of volumes of paper book of all the pleadings filed in this batch of read petition by the states of Assam, Arunachal Pradesh, Mizoram, and Nagaland respectively, by incorporating the responses stroke reports of the amicus curiae, if any, brought on record. Full stop. Apart from the 4 volumes as noticed above, registry may also prepare a separate volume of all the orders passed in this batch of read petition by arranging them date-wise with proper pagination. Stop. Let this matter be listed again. Let WPC number 5873 of 2006 be listed again on 25th of July 2023 after making necessary changes in terms of our above direction. Item numbers 6, 9, and 10 be listed separate, be segregated from this read petition and listed separately before the appropriate bench. In view of the above directions, WPC number so and so, মানে বাকি কেটে আছে 3, 4, 5, 7 and 8 would stand disposed of. That's fine. You bring your report, and give it to us, then we'll run a separate folder
Lordships,
to take care of materials which are generating, which affect from 25th.
lordships.
That will make things a little orderly, otherwise there could be conflicting orders.
Correct.
And on the next date, what we'll do is, we'll try to get the views as to how we can come up with some model. There are some suggestions already, but we need to customize. Every state has its peculiar need. Mizoram will have some features, Nagaland will have some features. Assam and Arunachal may also have some features. But it can't be a totally digress approach that somewhere you have a conference room bigger than the High Court and the ports as small as washrooms. These are also happening. These are absolutely, these are all happening because we are probably not focused on the area where we need to. So we'll try to thresh out these issues. And of course, this is not an adversarial forum. We are
Exactly.
trying to find solutions for everyone.
Exactly.
So whatever suggestions you have, not only as the state law officers, but even as in your individual capacity, please feel free to come forward with it.
Right.
And at some stage, we may also request the learned members of the bar to say if they have anything to say.
Yes.
Because these are all meant for all of us,
Yes.
for the entire institution. It is not to benefit any single branch of it. So with that, we postpone the matter till 25th.
25th.
Obliged.
Much only.
But one aspect. Since your lottery is directing that other petitions will stand disposed of, possibly one observation may be necessary. The issues involved in those petitions will survive and will be taken up in this petition.
Read it out.
That's it.
It will be subsumed into this writ petition and
Merged.
will merge into the issues. That's what we have said. Merge means it will survive. Anything else?
That's it.
That line has been given. So 11:15.
Is retiring next year. May I please, your lordship, with the consent of other side lordship, I beg to mention item number 29. May come after vacation lordship.
29,
Yes, lordship.
on the prayer of Mr. SSO, Learned Government Advocate.
CGC.
Learned CGC made with the consent of the other side, this matter stands adjourned. List after vacation.
Obliged.
May it please your lordship. Milord, my prayer is for listing of matter tomorrow, Milord. This is regarding Milord APSC prelims matter. Lordship will remember I withdrawn those matter with a liberty to file a fresh. I have already filed, Milord. If can be taken up
You
tomorrow.
are going to fight.
No, I have already filed.
Hmm.
So if can be taken up tomorrow, Milord. There is urgency. I leave.
That cases already 6/22 lordship.
No, those are separate cases now, Milord, because they did not withdraw. I withdraw and I file a fresh.
Let it be
Milord.
listed tomorrow. We'll fix it on 22. The only order will be passed is list again on 22 along with those matters. Or you want it on 22?
22, my lord.
All right, 22, right?
Lordship.
May it please your lordship,
I'll-
with the consent of the other, sir, I beg to mention item number 31, your lordship.
Hmm.
In the hearing column, your lordship.
Hmm.
Let me come after the vacation, your lordship.
Hearing or admission hearing?
Hearing, your lordship.
These are all hearing. All right, on the request of learned counsel for the writ petitioner, this matter, hearing of this matter stands adjourned for 4 weeks, list accordingly, yes.
Maybe
I'll
the
oblige, your lordship.
maybe the lordship. Lordship, I pray for listing of a promotional matter. The matter was reached upon on last occasion when the matter was reached upon, it could not be reached upon. I apologize. But your lordship, moreover, the petitioner will retire on this coming November.
First week of August. First week of August.
Deeply obliged.
May I plead your lordship? Lordship, I beg to mention item number 30 of the daily cause list.
Yes,
Lordship, matter may come up next week.
no. Why? Next week? Not
Lordship, the-
possible before vacation. Either you do it today or after vacation. As prayed for by learned counsel for the petitioner. Admission hearing of these matters stands adjourned for 4 weeks, list accordingly.
Obliged.
My lord.
May I please, Lordship? I beg to mention item number 26 and 27, Lordship. Lordship, matter may be adjourned, Lordship. It may come after
On the
vacation.
prayer of learned counsel for the writ petitioner, these matters stand adjourned for 4 weeks, list again after the summer vacation. Yes.
Much of that.
May it please, my lord, I beg to mention a matter for listing for Friday. My lord, it is a disciplinary proceeding matter. What has happened in the matter is that on the previous occasion, this honorable court has allowed us to sit for the promotional interview. Now the next promotional interview is round the corner.
Hmm.
I will miss it, my lord. I'll miss the part.
Have you filed any IA?
My lord, I.
No, then it cannot be listed. If you want any further relief, which was not before the court earlier, you have to file an IA, then the IA will be listed. Yes, next matter, please, yes.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 33, my lord, of the supplementary list.
Hmm.
Already affidavit sent for vetting, my lord. Lordship, may some accommodation.
Yes,
Considering to all the urgency, my lord, this one I'll fix the, Lordship may fix the date, my lord. That's why,
when?
Lordship may not. He's taking for 10 days time, my lord.
Item 33, Mr. S. Datta Learned SCP NRD Assam submits that counter affidavit on behalf of the department has been prepared and sent for waiting. As such, this matter be posted again after the vacation so as to enable him to bring the affidavit on record. Mr. P.K. Dekar, Learned Counsel for the petitioner is present and prays for fixing a firm date. In view of the above, admission hearing of this matter stands adjourned till 24th of July 2023.
Deeply
List the
obliged.
matter accordingly.
Deeply obliged. Highly obliged.
For admission, item 1.
May it please, Your Lordship. My lord, this matter, my lord, pertains to VRS benefit, my lord. The petitioner is an ex-employee of Assam Cooperative Sugar Mill Limited, my lord, Bogabamun Gaon. My lord, the mill was not functioning since 1996. Because of that, all the employees has not getting their salaries since 1996, my lord. My lord, in the year 2008, the Union of the Employees has approached this honorable court, and honorable court has directed the state government to take a decision within a specified period, my lord. After that, my lord, to give the benefits. But the same was not done. Because of that, the repetition was again revived, and later on, the later part of 2010, my lord, some benefit has been given. After that, my lord, the petitioner inquired that on what basis the benefits were calculated, but no any reply has been given to the petitioner from the respondent side, my lord. From others, he came to know that he has been given the benefits calculating on the basis of the Wage Board 3 pay structure, my lord, which was existed for a period of 5 years from 1988 to 92, my lord. My lord, the during the earlier repetition, it was held that Assam Cooperative Sugar Mill is also a PSU, public sector undertaking, as other public sector undertakings. As such, my lord, the petitioners has praying before your lordship for the benefit as benefit given to other PSUs, my lord. That is, my lord, the Wage Board was abolished in the year 1992, my lord. After that, the state government had to formulate the pay structure for the employees of the sugar mills, my lord. But the state government has not done that, and because of that, the petitioner deprived from the revised scale of benefits, my lord.
So it was closed, sugar mill was closed in 1992.
No, my lord, it was closed in the year 2010, my lord.
Hmm. And others have got it.
Others means, my lord, some benefit has been received, my lord, by other employees. Some other PSUs has getting, my lord.
Lordship, in this case, the petitioner have already received a sum of around 15 lakhs, your lordship, under the VRS scheme, your lordship.
So you already got VRS.
Yes,
VRS
Your
will
Lordship.
include everything.
Yes, my lord. Yeah,
Yes.
some of the benefit I have received, my lord. I have not denied, my lord. But my case is that, my lord, the wage board, the pay stacks are existing at the year 1988, my lord. The benefit has been given. After that, no any wage board was there. Because of
No,
that,
after voluntary retirement, where is the question of wage board?
my lord,
That is the end of your relationship with the employer.
my lord, for benefit of VRS, my lord, the pay structure was considered by the respondent as per the wage board 3, my lord. For other PSUs, it was as per ROP 1998.
We'll hear it. Admit for hearing, heard Mr. M. Sekal, learned counsel for the petitioner. Also heard Mr. G. Bordolay, learned
My lord,
standing counsel.
may I pray for another date for admissions, this, my lord?
Yes, yes. For appearing for the Cooperation Department. None has appeared for the Industries Department. After hearing the submissions made by the Petitioners Council, this court is of the opinion that this matter will require detailed hearing, which will not be possible today in the absence of learned standing counsel of the Industries Department. As such, registered to list this case again on 14th of August 2023 as a fixed item for admission hearing.
Oblige, your lordship.
Lordship, the matter may be passed over for the timing. Learned Standing Council.
No, the passed over will be for today. It is not convenient for us to pass it over. You want it after vacation?
After vacation, the date may be fixed.
Mr. P. N. Sharma, learned counsel for the petitioner, made with the consent of Mr. K. K. Parasar, learned CGC, appearing for the respondent. Admission hearing of this matter stands adjourned for 4 weeks. Let this writ petition be listed again on the 14th of August 2023 as a fixed item. Yes.
Public.
May it please, Your Lord. Yes. Actually, in this matter, my lord, the petitioner has challenged his dismissal as the secretary of a Gaon Panchayat, my lord, GPSS society. So when the matter was listed on the last occasion, the honorable bench raised a query with regard to the maintainability of the writ petition, my lord. That was raised because, my lord, I am an employee of a GPSS. Although I was appointed by the registrar, I was terminated by the GPSS without affording any opportunity and without a show cause notice. Now, your lordship desires, I'll address your lordships on the maintainability. Lord, I'll just give a brief narration of the facts, my lord.
You want a disposal today? Final
Or some
disposal.
other day, my lord, if it's for.
Are you ready for disposal?
Lordship may dispose it or may fix after the vacation, Your Lordship.
No, he was appointed by the cooperative.
No, he is an employee of the society, Your Lordship. Now, the appointment letter also says that he has been appointed on a temporary basis.
Where is the appointment letter?
Lordship,
Page
may-
15, my lords.
page 15, Your Lordship. Otherwise, he's an employee of the society. He is not under the government of Assam.
That
Your
is an
Lordship.
admitted position, my lord. I agree to that.
If your Lordship kindly come to,
Society means it's a private society.
it's a cooperative society. Now, he comes under the jurisdiction of the Board of Directors, Your Lordship. He's an employee under the Board of Directors.
The second paragraph, page 15. In the interest of
In
public
the public
service.
service, so and so.
Shri Lord.
So let the board of the cooperative society hear his grievance
Your Lordship, it can be done.
and pass a fresh
It's,
order.
because, my lord, admittedly, my lord, even in their affidavit, the cooperative society,
This order is of 2011.
my lords, that's order, I was terminated on, my lords, the impugn order, page 36, my lords. It's dated 2020, 2/09/2020. Now, the Corporation Department also admits to the fact, my lords, that I was not issued any show cause notice. In fact, the Register of Cooperative Societies themselves say, my lords, I should have been reinstated in service. Well, in fact, they support my case, my lords, the Corporation Department in their affidavit. And insofar as the GPSS is concerned, now they have come up with a very strange stance, my lord. After filing the writ petition, they file an affidavit in opposition, wherein they say now we have issued a show cause notice in the year 2022. After terminating me without notice and in the year 2020, they say now we have issued a show cause notice in the year 2022. So my lords, I may
Where
be,
is that stand?
my lords, my
Who is
lords,
appearing for the society?
Mr. F. Khan was there.
Huh?
He's there, your lordship.
No, we'll go ahead with the matter, sorry. Yes,
my lord,
where is their stand?
paragraph 10, my lord. Page 5, paragraph 10, my lords. May I read it now?
This is of the affidavit filed by,
The respondent number 7, which is the managing committee of Chopanola Cooperative Society Limited.
yes, and you are referring to
Paragraph 10, my lords. The statement,
yes.
the statements made in paragraph 7 of the petition, the deponent begs to deny the same and further states that as per the decision of the executive meeting dated 9/3/2022, the petitioner was served with a show cause notice by 15/03/2022, giving him ample opportunities to prove his innocence. Now, my lord would see the termination was in the year 2/09/2020. Paragraph 12, my lords, the reason of termination they have stated, my lords. Same, my lords, page number 7.
So anybody has been appointed in your place?
No, my lords, there was an in charge, my lord, but the corporation department cancelled his in chargeship and directed me to be reinstated. That my lords would find. Lordship may take up, kindly take up the writ petition, page 35, my lord. The document is very important, my lord. Page 35. Now, this is the letter by the zonal registrar, joint registrar of cooperative societies to the assistant registrar. Sir, with reference to the subject above, I am to inform you that the inquiry report submitted by letter under reference revealed that shortage of whole meal atta in the society was due to non-lifting of 48.87 quintal of atta from the mill by the secretary due to short storage capacity facility of the godown of the society, and the owner of the atta mill is ready to supply the same to the society. Again, regarding NFSA rice so and so, my lordship may skip that paragraph, the last paragraph. Giving honor to the decision of the BOD so and so regarding suspension of Sri Lambudra Gogoi so and so for 90 days, you are hereby asked to direct the board of directors in the said society to allow Sri Lambudra Gogoi, the petitioner, to continue as secretary so and so after expiry of suspension period, that is 90 days on so and so, and all temporary arrangement in case of secretary of the society, if made, may be suspended in the greater interest of society and for the interest of cooperative spirit.
So this order of termination issued on 2/9/2020, is it not appealable?
It's not, it's pursuant to this order, my lord. There's a direction by the cooperative societies that you reinstate him. And my lord, if lordship goes by the bylaws, I could not have been terminated without the approval of the registrar. My lord, can I place the bylaws, my lord? Then the, my lord, lordship would take up the act for a moment, my lord. There's one point, my lord, I'd like to praise this court, my lord. So this GPSS in question. By the Cooperative Society Act 2007. Bylaws studio, English translation.
Cooperative, which
My
section?
lord, lordship first turn to paragraph, my lord, section 3, my lords. Section 3. The registrar, the state government may appoint an officer to be the registrar of cooperative societies for the state of Assam or any portion of it for its registration supervision. Now, registrar is responsible for overall supervisions of the cooperative societies. My lords would come to section 38, my lord, thereafter, my lords. Section 38, my lords. May I read them? The board shall discharge such functions, perform such duties, and exercise such powers as may be specified in the bylaws and in accordance with the terms and conditions and the procedure laid down therein, and in particular, the board shall have the following powers, functions, and duties, namely, number 2, my lords, to nominate, elect, or appoint and remove the chief executive, provided he is not a government appointee. Now, my lords, chief executive is the secretary. The secretary is synonymous, it's also called as the chief executive. Now it says, my lord, 38, that it has to be in terms of the bylaws. The statute clearly provides, my lord. Lordship, may kindly have a look at the bylaws, my lord, for a moment. May I read the vernacular first, then refer to the English translation, my lord?
Yes, please.
My lord, Hompadok. Lordship have it, my lord? Hompadok. One.
Yes.
পঞ্জীয়ক আৰু অৰ্থ যোগান ধৰা বেংকৰ পৰা আগতীয়া অনুমোদন লৈ কাৰ্যকাৰী কমিটিয়ে সম্পূৰ্ণ বেতনভোগী সঞ্চালক সম্পাদক নিয়োগ বা অপহৰণ কৰিব পাৰিব। প্ৰয়োজন বিবেচনা কৰিলে সমবায় সমিতি সমূহৰ পঞ্জীয়কৰ কাৰ্যকাৰী সঞ্চালক সম্পাদক নিয়োগ কৰিব পাৰিব। কাৰ্যকাৰী সমিতিৰ বা চৰকাৰৰ নিয়োজিত সম্পাদকৰ সমিতিৰ মুখ্য কাৰ্যকাৰী বিষয়া হ'ব চৰকাৰৰ দ্বাৰা নিয়োজিত। The first paragraph would suffice, my lord. I'll read the English translation, my lord. It's been translated by an official translator, my lord. The executive committee.
So according to you, this order could not have been passed without prior approval.
Prior approval of the registrar of
Plus,
courts.
it is in violation of principles of.
Even they state, my lord, in their affidavit that it was not passed without the prior approval of the.
That is the stand. What is the stand of the department?
Department, I'll read it out, my lord. Just 2 paragraphs, my lord.
Who has filed the affidavit here?
It's the assistant registrar of cooperative societies. My lords would turn to come directly to page 3, my lords. The first paragraph, 1, 2, 3, 4, 5. 5 lines from the bottom, my lords. Page 3, first paragraph, 5 lines from the bottom.
What is the affidavit? Is there a counter affidavit filed by the assistant registrar?
Yes, my lord. Someshwar Metak. Affidavit in opposition filed on behalf of the respondent number 6. I have an extra copy.
No, it has to be, is it there in the record? This has to be in the seat. Should it do?
By the time he finds out, lordship may refer to the under the copy. Page number 3, my lords. The first paragraph, 5 lines from the bottom, my lord. This is paragraph.
Page number 40.
Yeah. Yes, page number 3.
Page number 3, the first paragraph, my lord. 5 lines from the bottom. My lord.
Yes.
The Board of Directors of Chapanala Samabay Samiti Limited by the meeting dated so and so as per proposal number 1 terminated the service of Lombudhar Gogoi, the present petitioner from secretary without any show cause notice, show cause explanation call by giving any opportunity for his defend. The period of suspension expired on so and as per the
You
instruction
are
of the-
reading from paragraph?
page 3, my lord. It's paragraph 4 starts at page 2, but I'm referring to page number 3, my lord.
Page number 3, which part? It begins with 19 pandemic.
No, my lord, on 19 pandemic, right, my lord?
Then
The first paragraph, if your lordship takes up 5 lines from the bottom of the first paragraph of that paragraph itself, my lord, not the second one. The board of directors, my lord. The board of directors of Chapanala Samabay Samiti Limited by the meeting dated so and so as per proposal number 1 terminated the service of Sri Lombudhar Gogoi, the present petitioner from secretary without any show cause notice, explanation call, or by giving any opportunity for his defend. The period of suspension was expired on so and as per the instruction of the zonal joint registrar cooperative societies Guwahati, the assistant registrar of cooperative societies Koliabor issued a letter to the board of directors of Chapanala Samabay Samiti by the letter dated so and so asking them to allow Sri Lombudhar Gogoi to join as the secretary. My next paragraph, my lords, next page, paragraph number 5, my lord. 5 lines from the top, my lord, the answering deponent. The answering deponent then asks both orally and in written to the board of directors to issue show cause notice and fix a date for hearing. Later, the answering deponent issued a letter to give show cause notice or hearing so and so, but the board of directors did not do it. Now, my lords, paragraph 9, page 5. That as the statement made in paragraph 12 and 13 of the answering deponent begs to say that the board of directors have not issued any show cause notice to the petitioner and rather has terminated the petitioner from the post of secretary without giving a chance of being heard, despite having an order of the zonal joint registrar cooperative societies Khanapara. Lordship would turn to the annexure, my lord. Just 2 annexures I'm referring, my lord. Page 10 and 11, my lords. This is by a letter by the assistant registrar to the chairman of the board, my lord, the GPSS. Sir, with reference to the subject cited above, I am to inform you that the BOD meeting held on so and so has removed CEO of your society, Sri Lombudhar Gogoi, by resolution 1. But as per bylaw of the society under 28(1), which I just read, my lord, in Asmis, the appointment and removal of the CEO also shall be full-time in so and so shall be made by the board with the prior approval of the registrar and the financial bank, provided further that the registrar may also appoint the chief executive officer if he deems fit and proper. As you know, as per government rule, if the BOD wants to remove an employee from his post, then you should have given time to him, giving a chance for his defense, and you must ask him by issued show cause explanation so and so why disciplinary action will not be taken against him, but you are not done it. This is the stand of the department. And my lord, I may be allowed to point out, my lord, this GPSS is not an ordinary GPSS, my lord.
what do you have to say on the maintainability issue?
Maintainability. I'll first address your lordship on the maintainability. First and foremost, my lord, I've referred to section 3. Section 3 says, my lord, that the
No, what is the submission on that?
My lord, yes. Because, my lord,
Particulars you give later. What is the submission?
submission, my lord. Submission because there has been infraction of a statutory mandate. Because, my lord, 38 provides that the BOD has to follow the bylaws. Now, as per the bylaws, it's a condition precedent that before removal of the secretary, the approval of the registrar has to be taken. Now, my lord, secondly, my lord, I was appointed by the registrar of cooperative societies. And the cooperative society, what we are dealing with, my lord, it's not an ordinary cooperative society. It's a cooperative society which deals in the distribution of essential goods PDS. My lord.
Where is the judgment of G Telefilms Limited?
Z is not there, but other I have.
Which you have?
They have referred to Z, my lord.
Who has referred to Z?
This my lord, Ramesh Aluwalia, my lord. It's 2000. Supreme Court, my lord, 2012.
This GPS is involved in distribution of.
Yes,
credit cards.
I have made a categorical statement. There is a additional affidavit in that regard. So here, a private employee of an unaided school was terminated. I'll directly come to the finding. My lords, internal page number 3, my lords, numbering is at the bottom, my lords. Font is small, my lords. Second paragraph. Aggrieved by the aforesaid decision, the appellant challenged the order of the disciplinary committee before the High Court by filing so and so. The aforesaid writ petition has been dismissed by the learned single judge in limine, but by passing a speaking order, relying on the judgment of this court in Z Telefilm so and so, the appellant had submitted that he was entitled to invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution of India, as the respondent school was performing public functions by providing education to young children. The aforesaid submission of the appellant has been rejected by the learned single judge. Now, what happens in the writ appeal, my lords? After hearing the counsel for the appellant, I do not find any force. These were the observations made in the report. I do not find any force in the contention raised by him. The respondent school being an unaided and a private school being manned by a society is not an instrumentality of state, in my opinion, and the appellant has the efficacious remedy to challenge the impugn orders before the civil court. In the instant case, while challenging the impugn orders, the appellant had raised certain disputed questions of facts. Thus, in facts and circumstances of the case, I am not inclined to entertain the petition, and the same is accordingly dismissed with liberty to the appellant to avail his alternative remedy. Against the order passed by the learned single judge, the appellant filed letters patent so and so. It was also dismissed, my lord. Thereafter, my lords, the submission made by the appellant before the Supreme Court. Mr. Parikh, learned counsel appearing on behalf of the appellant, submitted that the judgment of the learned single judge as well as also the division bench of the High Court are contrary to the law laid down by this court in a katina of judgments. He has made reference of this court in so and so, so and so, so and so, so and so, and submitted that even though respondent school would not.
Where is the law ratio of this?
Yes, my lord, ratio, my lord, would directly come to my lord, paragraph, page number 4. The last two paragraphs would suffice, I hope. My lord. The aforesaid observation have been repeated and reiterated in numerous judgments so and so, including Unni Krishnan, Z Telefilm so and so. In view of the law laid down in the aforementioned judgments, the judgment of the learned single judge in the division bench of the High Court cannot be sustained on the proposition that the writ petition would not be maintainable merely because the respondent institution is purely unaided private educational institution. The appellant has specifically taken the plea that the respondents perform public functions, that is providing education to children, institutions throughout India, my lord. The other judgments also are. Now, my lords, there's an additional affidavit if your lordship takes it up, where I have taken this categorical statement. Additional affidavit. My lord, find an additional affidavit filed by the petitioner. My lord. The running page number is 112, my lord. Hmm. 114 is my submission, and I have also annexed the document, my lord, in that regard. Paragraph 4, page 114. The petitioner humbly begs to submit that the Sopanola Samabhai Committee, which is a GPSS in the state of Assam, is involved in the procurement, storage, transportation, and distribution of commodities to consumers, mostly BPL families, through PDS work, PDS network. Public distribution system has evolved as a major instrument of the government's policy for ensuring availability of food grains to public at affordable prices, as well as enhancing food security of the poor. GPSS in the state of Assam is also essential for achieving the aims and objectives envisaged by the National Food Security Act 2013. As such, respondents have in GPSS, which performs essential public functions, would be amenable to the writ jurisdiction. Now, there is a document, page 116, where the government itself states that GPSS is essential for supply of PDS goods. It's equivalent to a ration shop. What I do as a GPS is I supply the food.
Yes, what do you have to say, Mr. Botula?
He supports my standpoint.
Otherwise, your lordship, coming to the terminations and the appointing authority, it is the society, your lordship. That has to be dealt with by the society, your lordship. Because he has the only stand that has been taken by the department is there are several letters that has been issued to the chairman of the society, considering the suspension of the.
What is the allegation against him?
Allegation, your lordship, they have been found with shortage of atta, your lordship.
But the report shows that it is for reason.
Yes.
My lord, the department absolves me, my lord.
The food
After
and
all-
civil supplies, they have conducted an inquiry, your lordship, and based on that inquiry, the petitioner has been found that he is not guilty, your lordship.
Absolved police court order document page 35.
Hmm.
Page 35, lordship would kindly see, my lord.
Yes. Who is appearing for respondent number 7? What do you have to say? What is your submission first? Tell us.
My lord, we have taken a resolution, my lord.
What is your submission first? Tell us.
First of all, my lord, he was found involved in some irregularities. Later on, he was absolved, my lord.
Hmm.
But in our inquiry, we have found
Hmm.
that there are irregularities and there were many complaints also against him.
Hmm.
So we have removed him.
All right. Have you issued any notice? Have you
Yes.
heard it?
Notices are there, but he have not appeared. He have not filed. a
Notice was
report.
issued before termination or after termination?
My lord, before termination also there was a notice,
Where is the statement?
our affidavit in opposition.
Yes, where have you stated?
Fifteen three তাত show কৰি আছে ন?
Hmm. Are you going to prepare your case now and argue?
No, my lord, what happened, my lord?
Where is the statement that you have issued notice to him
My
prior to? If there is no statement, Mr. Khan, please
There are
take your,
12, there is one statement. my
what
lord.
is the statement? Let us.
That as regards this to the statement made at para 10 of the
Hmm.
petition that the answering deponent begs to state that the petitioner was not reinstated as because it was unanimously decided in the meeting dated 26/8/2020
Hmm.
not to reinstate the petitioner since the petitioner was found guilty of corruption as per the investigation directed by the Deputy Commissioner Nogao and as per the investigation report of the Assistant Registrar Kolyabur. Thereafter,
But we are not interested in knowing all this.
thereafter, on 2 occasions, the petitioner was served with so cause notice. However, he has not submitted his reply till now for the reasons best known to him. Annexus 6.
Was
What
any
would be
show
the
cause
date, madam?
notice issued to him before the order of termination was issued?
27/5.
27/5. This is the notice, my lord, but his termination was on
2/9/2020.
2/9/2020.
Hmm.
And he,
So this order of termination was issued in violation of principles of natural justice. You come here and sit.
para
first.
7,
Hmm.
para 7, my lord, of my affidavit of opposition, my lord.
Hmm.
The petitioner was heard, my lord. Para 7.
All right, now you take your seat. We can't waste time like this.
My-
Yes. Heard Mr. P. Montal and counsel appearing for the writ petitioner. Also, Mr. Chutia, you have anything to say? All right. Mr. P. Montal and counsel appearing for the writ petitioner. Also heard Mr. G. Bordelais, Learned Standing Council, Cooperation Department, Assam, appearing for the respond numbers 1, 3, 4, 5 and 6, Mr. T. C. Chutia, Learned Additional Senior Government Advocate Assam appearing for the respond number 2, and Mr. F. Khan, Learned Counsel representing the respond number 7, Ulster. The writ petitioner hearing was appointed as the secretary of Secretary of the Chapanala, CHAPANLA, Samabhai Samati Limited by the order dated 16/5/2011 passed by the additional register no, right. No, Mr. Petitioner so-and-so was allowed to, no, petitioner who was functioning as the office assistant of the Chapanala Samabhai Samiti Limited was allowed to function as the in-charge secretary of the SS Limited by the order dated 16/5/2011 issued by the additional register of cooperative societies bracket admin bracket close Assam, Khanapara. He was thereafter confirmed as secretary.
No, my lord, it was with the approval of the Registrar of Corporations. Thereafter, he was suspended, my lord, page 19. Then removed.
While the petitioner was functioning as the in-charge secretary of the Chapanala SS Limited by the order dated 5/6/2020, he was placed under suspension
For 90 days, my lord.
for a period of 90 days based on a resolution adopted by the Board of Directors of the Chapanala SS Limited. Thereafter, by the order dated by the impugned order dated 2/9/2020, the services of the petitioner as the secretary of the Samabhai Samiti was terminated. The instant writ petition has been filed assailing the order of termination dated 02/09/2020 primarily on the ground that the order of termination was violative of the principles of natural justice and administrative fair play. Full stop. By referring to the materials available on record, Mr. Mahanta has argued that as per the provisions of the of section 38 of the Assam Cooperative Societies Act, 2007, bracket hereinafter referred to as the Act of 2007, read with Rule 27 of the bylaws framed thereunder. The Board of Directors could not have removed the petitioner without serving him show cause notice and without obtaining the approval of the Register of Cooperative Societies. Therefore, it is a clear case where the respondents have not only acted in violation of the principles of natural justice, but also in contravention of the provisions of the Act of 2007 as well as the bylaws framed thereunder. First up, Mr. Bordoloi, Learned Standing Council Corporation Department has referred to the counter affidavit filed by the respondent number 6 to submit that the action on the part of the board in removing the petitioner from service was not found to be valid, as a result of which instructions were issued by the department to reinstate him. However, no action has been taken in the matter by the board. Full stop. Mr. Bordoloi further submits that the departmental inquiry conducted in the matter has found that the petitioner was not involved in any irregular activities, as a result of which he has been exonerated from the allegations brought against the petitioner to the effect that he was responsible for shortfall of supply of atta in the storage. full stop. Next para. Mr. Khan, Mr. Chutia, learned additional senior government advocate Assam, has adopted the submission made by Mr. Bordole, reflected herein above, full stop. Mr. Khan, learned counsel representing representing the respondent number 7 submits that there were serious allegations which were found to be correct as per the domestic inquiry conducted by the Board of Directors of the Chapanala SS Limited, prompting them to issue the order of termination dated 2/9/2020. Full stop. It is also the submission of Mr. Khan that show cause notices were issued to the petitioner, to which he had failed to respond. Full stop. The learned counsel for the respondent number 7, however, could not deny the assertion that no such show cause notice was issued to the petitioner before the order of termination dated 2/9/2020 was passed, was issued. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. Since the impugned order dated 2/9/2020 had been issued by the Board of Directors of GPSS. It is called Gaon Panchayat Samabhay Samiti Limited.
GPSS.
GPSS, bracket GPSS. The learned single judge had raised the question of maintainability of the writ petition, which is evident from a reading of the order dated 2/1/2023, passed in this proceeding. Full stop. To satisfy this court that the order, the writ petition does not suffer from any issue of maintainability, Mr. Mohanto has submitted that this is a clear case of violation of provisions of the statute. Since the GPSS Limited, since the GPSS in question was involved in discharge of duties and functions which were in the nature of public duty, hence, in view of the law laid down by the Supreme Court in the case of Andi Mukta Sadguru Sri Muktaji Vanda Swami Suvarna Jayanti. This judgment is very good, as well as Z Telefilms Limited and another versus Union of India and others reported in 2005 bracket close 4 SCC 649. A writ petition brought against arbitrary action of the authority governing such institutions would be maintainable in the eye of law. Full stop. Mr. Mohanta has also submitted that in the affidavit filed by the respondent number 7, it has been clearly stated that a show cause notice dated 15/3/2020 was issued to the petitioner, and therefore it is apparent that even the respondent number 7 was conscious of the fact that the board ought to have served a show cause notice upon the petitioner before issuing the order of termination. Full stop. Next paragraph. From a reading of section 3 of the Act of 2007, I find that the Register of Cooperative Society to be appointed by the government of Assam is an officer who would have the responsibility of overall supervision, assistance and counsel, and the duty for all-round development of the cooperative movement in the state. with such other powers and responsibilities as may be provided under the Act or rules or bylaws framed thereunder. Full stop. As per rule number 27 of the bylaws of the GPS of the GPSs Limited, the executive committee was required to obtain the approval of the register before appointment or dismissal of a regular salaried director, public secretary. It is for this reason that the order of appointment of the petitioner as in-charge secretary of the GPSs had the approval of the additional register of cooperative societies. First of all. However, there is no dispute about the fact that the approval of the register of cooperative societies was not issued before issuing the order of termination dated 02/09/2020. First of all. Law is well settled after the decision of the Supreme Court in the case of Z Telefilms Limited that any organization involved in discharge of public functions would be amenable to read jurisdiction under Article 226 of the Constitution of India. First up, in the present case, what is to be noted here in that the Chapanala SS Limited is a GPSS which is used, which is involved in the matter of procurement, storage, transportation, and distribution of commodities to the consumers who are mostly the BPL families through PDS network, a public distribution system, PDS network. Therefore, the GPSs in the state of Assam are a part of the government machinery to fulfill the policy objectives of the government under the National Food Security Act 2013. First up. As such, it is for this reason that for certain purposes, the functioning of the board of directors of the GPSs have been made subject to approval of the Register of Cooperative Societies. First up. In other words, a close reading of the provisions of Act of 2007 and the bylaws go to show that the state of Assam, through the Office of Register of Cooperative Society, has deep and pervasive control over the functioning of the GPSs, more particularly in the matter of appointment and removal of Director, Public Secretary. First up. Therefore, this court finds force in the submission of Mr. Mahanta that the GPSs Limited would be other authorities within the meaning of Article 12 of the Constitution of India, and therefore would be amenable, and therefore the action of such authority would be amenable to the writ jurisdiction of this court under Article 226 of the Constitution of India. First up, the question of maintainability is therefore answered in the above. First up. Coming to the next issue as to whether the order of termination from service dated 02/09/2020 suffers from illegality on account of violation of the rules of audi alteram partem, as has been noticed above. The respondent number 7 had issued a show cause notice to the writ petitioner, but the same was done after the order of termination dated 2/9/2020 was issued. First up. The above developments clearly go to show that even the respondent number 7 was conscious of the fact that the order of termination was required to be preceded by a show cause notice served upon the petitioner, thus giving him an opportunity of being heard in the matter. Full stop. However, no such requirement of law was fulfilled in this case. Full stop. There is also no approval obtained from the Register of Cooperative Societies before removing him from office. As a matter of fact, the Register of Cooperative Societies had not approved the fact that the Register of Cooperative Societies had not approved the removal of the petitioner from office is evident from the instructions issued by the by the order dated
Page 35 maybe, madam. 11/8/2020.
from a bare perusal of the order dated page 35, is it?
Number of orders, madam, where it has been
Bare
stated
perusal
35.
of the order dated 11/8/2020 issued by the Zonal Joint Register of Cooperative Societies, Guwahati Zone, instructing the BOD of the SS Limited to this is for suspension, Mr. Mohanto.
My
This is
lord,
not for restoration.
thereafter, if Lordship would read the next two paragraphs. And also, my lord, in the affidavit,
Oh, where is the order asking him to be reinstated?
my lord, it's there, page 35.
That is not the order. Order dated 8/9/2020. Issued by the Assistant Registrar of Cooperative.
Oh, I'm so sorry, my mistake, my lord.
By means of which the decision of the BOD in its meeting held on 3/6/2020 to suspend the secretary was disapproved with a request to allow him to continue as secretary of Chapanala FS Limited. Full stop. Next para. It would also be pertinent to note herein that as per the response number 7, there were serious complaints against the petitioner of irregularities in the matter of storage of food grains, more particularly atta, which had led to the BOD to take stern action in the matter. If that be so, it was all the more necessary for the board to serve as show cause notice upon the petitioner. Thus, so as to give him an opportunity of submitting his reply. First of the failure to do so assumes all the more significance in view of the communications placed on record, which goes to show that the petitioner had no role to play in the shortage of atta in the storage of the GPSS Limited. First of viewed from that angle also, the impugned order dated 2/9/2020 appears to this court, appears to have been issued in utter contravention of the principles of audi alteram partem, since the same was not issued after giving an opportunity of being heard to the petitioner. For the reasons stated herein above, this court is of the opinion that this that the petitioner has made out a good case for interference with the order of termination from service by this. As such, this writ petition succeeds and is hereby allowed. The impugned order dated 2/9/2020 is hereby set aside. The response number 7 is directed to reinstate the petitioner back in service forthwith. First off, the response numbers 1 and 3 to 6 will ensure the compliance of the order of this court within 10 days from today. First off, upon such reinstatement, it will be open for the board of directors to take fresh action in the matter after serving proper show cause notice upon the petitioner. First up, in the event any inquiry is proposed to be held against the petitioner, the same shall be done in strict compliance of the requirement of the Act of 2007 and the bylaws framed thereunder. With the above observation, read petition.
Maybe entitled some consequential relief.
What consequential relief? You are not entitled to.
Deeply obliged.
May please your lordship, my lord. In this matter, we have prepared the affidavit and sent it for vetting, my lord.
Mr. P. N. Sharma, learned counsel for the petitioner is present. Ms. M. D. Bora, learned government advocate Assam, has appeared in submit that the affidavit prepared on behalf of the department has been sent for vetting.
My lord.
As such, this matter be posted again after the summer vacation. In view of the above, admission hearing of this matter stands adjourned for 4 weeks. Mr. Conway.
I'm deeply obliged, my lord.
May I please, my lord? My lord, with regard to a departmental proceeding and the penalty imposed upon me, what had happened, my lord? This man, he was an executive engineer. He was subjected to 2 departmental proceedings. One in 2017, which is concerned in the present writ proceeding, and the other one in 2018. The department proceeding in 2017, my lord, the report was submitted in 2018. They sat over the matter. It was only in 2021 that, my lord, a penalty was issued on me of 1 increment, withholding of 1 increment without cumulative effect. Now, in the 2018 show cause, my lord, that led to my exoneration. But before issuance of that show cause, because there was a criminal case involved in that, I was placed under suspension. And my increments were stopped from 2017-18 onwards. Now, after the penalty came into being, my lord, in the first show cause of 2017 in 21, this was communicated to the AG. The AG accordingly, my lord, 1 increment has to be deducted. It deducted 1 increment because on being placed under suspension from 2017, no increments were being released to me. So the AG, my lord, withheld 1 increment and accordingly issued to me a fresh charge sheet. Wherein, my lord, in 2018, that withheld increment along with the increment of 2018 was given to me. So my penalty, my lord, suffered, finished. 2021, my lord, they hold a DPC. Then after, my lord, all this thing has happened. I informed this to the authorities also. They keep my case under seal cover. Now they have come up with an affidavit. They say that your increments were withheld, not withheld with regard to the first show cause. It was withheld with the second show cause. So that is of no use. My lord, increments are only 1. Whether it's with regard to the first or to the second, can't make any difference, my lord. This is, my lord, my case. Because of that man has already retired. He retired on 31st, my lord, of March, but during the pendency of this proceeding. So, my lord, if
Is there any urgency in the matter?
urgency only, my lord, the persons, he is hanging, my lord. Otherwise, he gets superintendent engineer. He, my lord, the person at serial number 2 has already been promoted.
No, he is not hanging. He is not relaxing. He retired.
Subject to what, my lord?
Have you filed your rejoinder?
I'm not filing, my lord. That itself will do.
Perhaps you will have to file a rejoinder.
My lord,
You will have to file a rejoinder.
I'll do that, my lord. I'll do that, my lord. I'll clarify that.
And then we'll proceed because since they have taken a stand in the affidavit. A rejoinder will be, and what is the relief that can be granted to your client now?
My lord, if my lord clarifies the position, because the DPC has, my lord, not kept my case under seal cover. So that seal cover has to be opened, my lord. If that seal cover of today 1 is opened, then, my lord, my person at serial number 2, he is already promoted. So from that day, I should be given the benefit, man. That much only.
That is correct.
That much only.
If you succeed, then
That much only relief I can expect, my lord.
So you think a rejoinder?
I'll file it.
Let him file a rejoinder. Mr. UK Nair and a senior counsel listed by Ms. So has appeared for
Yes,
the-
Acharya.
as Hazarika has appeared for the petitioner and submits that although his client has retired from service with effect from 31st
March.
March 2023, yet the relief sought for in this writ petition is still a live issue, and therefore he be granted 3 weeks time to complete his instruction and file rejoinder affidavit responding to the counter affidavit filed by the respondent number 2. Miss R.
Arbor Lordship,
Standing Council.
Agriculture Department.
Agriculture Department, Assam, as well as Miss S. Barua, learned government advocate, Assam, are present on behalf of the official respondents and do not have any objection if the prayer is allowed. In view of the above, let this writ petition be listed again after 4 weeks for admission. In the meantime, the petitioner may file rejoinder affidavit if so advised.
Obliged.
Much obliged.
May I please, Lordship? No, this is a matter, Lordship, relating to upgradation from one post to higher post, Lordship. Lordship, the petitioner, Lordship, challenge made in this petition is the order dated 5/5/2022, Lordship, page 66. You are appearing in which writ petition number? My lord, 33239
Of 2022.
my lord, 2022.
So it seems there is a departmental proceeding pending.
My
against
lord, that has already been ended, and lordship, departmental proceeding has been dropped as nothing was proved against the petitioner. Lord. That has already been annexed in their counter affidavit. That petitioner has been exonerated,
Petitioner has been exonerated.
my lord.
So now what is the relief you are seeking?
My lord, my submission is that the lordship, the junior lordship, who are the respondent number 7 and 8, they have been given the higher post lordship. And before that lordship, the department of proceeding was initiated in the year 2000, March 2020 lordship. That is 6/3/2020. That was not lordship ended, that subsequently filed a writ petition when they
There
have,
was no seal cover proceeding.
my lord, that was not done.
You also didn't ask for it.
My lord,
You also didn't ask for it.
my lord.
You didn't pay for it.
My lord, they have annexed that notification also, that the case of the petitioner should be in the seal cover lordship. That was not done in this previous case.
Where is that?
My lord,
It should be. in
they
seal
have
cover.
issued, my lord. They have mentioned in their affidavit lordship. Page 75, running page. Page 75 lordship. They have issued, annexed that notification when the departmental proceeding is drawn against a particular person, delinquent. If any. That's 75. Page 70. Running page.
Page 75.
My lord, in the running page.
Yes. What
My
do
lord,
you
it is last paragraph, lordship. It is noteworthy to mention here that an officer having any departmental proceeding pending against him is not considered for promotion to a higher post till disposal of the departmental proceeding as per government of Assam notification office memorandum, the number so and so, dated so and so. The recommendation of the departmental promotion committee, selection committee, appointing authority in respect of such government servant is placed in the seal cover till disposal of the departmental proceeding. My lord, that is the notification that they have annexed. My lord, but
That's correct, but petitioner's case was kept in seal cover.
no,
Then you have to constitute a review DPC and consider his case for promotion.
Yes, my lord, we have stated here, my lord, the case of the petitioner will be considered in due course, my lord.
No DPC.
No junior was, my lord, promoted, my lord. No, there is no promotion, my lord.
Who are the juniors to be?
my lord, kindly see the gradation list, lordship, that is annexed lordship, page 56. Page 56, serial number lordship 10. And this is the draft provisional gradation list. Subsequently, it was made final.
What is the name of the petitioner?
My lord Sumon Das, lordship, is serial number 10. And 11 and 12, lordship, Abdul Hanif and Junali Patgiri, they are the private respondent, lordship. Their cases have been considered, that is page 66.
They are promoted to.
My lord, they have been upgraded. My lord, what upgraded has been not been mentioned. The post given to them is the higher post.
What is the post? Can you tell me?
Same post, my lord, same post.
Not the same post.
Same post, my lord. Not higher post.
No, they were the district commandant, now posted as divisional commandant. Abdul Hanif. Divisional commandant is the. And Junali Patgiri lordship, she was the district commandant, that was the lordship additional SP rank. And now lordship, the divisional commandant, that is the SP rank. Earlier it was additional SP rank.
And where is the order by which the petitioner has been exonerated?
My lord, that is in their affidavit lordship 99. Lordship running page 99.
So these private respondents are holding posts equivalent to the rank of SP. There is
No, my lord, lordship, can you see our affidavit, my lord, page 106. 106, it is the rules, my lord. This is the Assam Gazette, my lord, the rules are under.
Mr. Chutia, first, what is your submission you have to tell to me?
My submission is, my lord, the petitioner, my lord, he was under my lord, departmental proceeding. That departmental
Yes.
proceeding.
He has
that
been
was-
exonerated.
They are exonerated, my lord. Now the person what, my lord, they are not upgraded, my lord, they are subject to availability of post, they are being given this post. And lordship kindly see the rules, my lord.
Where is the order of promotion of these private respondents?
Last page, my lord, I think.
Last page 66. Of the writ petition.
5/5/2022. The interest of public service Abdul Hanif, Assam Home Guard so and so district commandant, Home Guards rank of additional SP rank is transferred and posted at divisional commandant Home Guards, Hills and Division, sub so and so so and so. And divisional commandant, the divisional commandant and they are the same post, my lord.
It says additional SP rank, Mr. Khan.
My lord, divisional commandant is
No,
the
no, my
SP
lord.
rank.
Sorry, where is the order of promotion?
No, my lord.
My lord, that is the
Same
order.
post was
I heard
transferred.
Mr. Khan, learned counsel for the writ petitioner, also heard Mr. Chutia, learned additional senior government advocate Assam appearing for the respond numbers 1 to 6. Is it?
Yes, my lord.
1 to 6. None has appeared for the private respond numbers 7 and 8. First up, the case of the writ petitioner, briefly stated, as projected in the writ petition is that while serving as the second in command, additional SP rank, close, in the Assam Industrial Security Force, AISF, close, capital B small and battalion dot Roman 2, Chabua, Dibrugarh. A show cause notice dated 6/3/2020 was issued to him. Bringing certain allegation against the petitioners. Full stop. The show cause notice dated 6/3/2020 was ultimately taken forward so as to draw up a departmental proceeding which culminated in the
Yes, 99.
order dated 19/7/2022 issued by the Principal Secretary to the Government of Assam, Home and Political Department, thus exonerating the petitioner in respect of the charges leveled against him. First up. the petitioner has approached this court by contending that during the pendency of the departmental proceeding, persons junior to him, namely these respondent numbers 7 and 8, have been promoted to the higher posts, that is, posts equivalent to the rank of superintendent of police. Full stop. However, the case of the petitioner was not considered in a seal cover, thereby resulting in serious prejudice to his interest. Full stop. By contending that in cases where departmental proceedings are pending against government servants, their cases for promotion is required to be considered under seal cover. Mr. Khan submits that in the present case, the authorities have not acted in accordance with the Government of Assam Office Memorandum number ABP 29/2006/38 dated 9/5/2006, which mandates that case of candidates coming within the zone of consideration for promotion must be kept in seal cover during the pendency of the departmental proceeding. Full stop. Mr. Chutia, learned additional senior government advocate, Assam, on the other hand, submits that no junior officer to the petitioner has been promoted to a higher rank during the pendency of the departmental proceeding. Full stop. Since the petitioner has now been exonerated of the charges brought against him by order dated 19/7/2022, his case for promotion to the next higher rank will be considered in accordance with law, along with his juniors, along with other departmental candidates coming within the zone of consideration. Therefore, no further order is required to be passed in this case. Full stop. Next, the fact that the petitioner has been exonerated in respect of the charge leveled against him is not in dispute. Full stop. The only question is whether any person junior to the petitioner in the gradation list have been promoted during the pendency of the promoted to the higher rank during the pendency of the departmental proceeding. First step. Although the petitioner had made an assertion, although the petitioner's counsel has made an assertion to that effect, there is nothing on record to substantiate the above claim. First step. It is no doubt correct that the respondent numbers 8 and 9, 7 and 8 are junior to the petitioner in the gradation list. However, there is no notification placed on record by the petitioner to show that those two persons had been promoted to a higher rank during the pendency of the departmental proceeding, thereby causing prejudice to the interest of the petitioner. First step. The document relied upon by the petitioner's counsel.
Page 30 is that is there.
Yes,
Page 38.
page 38, yes.
That is
Relied upon by the petitioner's counsel.
5
in
and
the form of
6. Serial number 5 and 6, your worship will see the divisional commandant, 1 star, 1 Ashok emblem, and district commandant. That is the next rank.
To the same ring, Madam Lordship, 106 is a notification. Lordship kindly see it is the second in commandant and divisional commandant, same rank. 106, our notification.
Where is the notification you have relied
My lord,
upon?
page 38, your lordship relevant, start from 36.
No, you just showed a notification by which they were asked to in charge, function as in charge.
These are the different rules, my lord. These were called Assam Home Guards Amendment Rule 1915. These are the service rules. I am placing the service rules, my lord, page 106.
Why don't you start from the Constitution of India, Mr. Chutia? I am asking a simple question. Where is that notification by which you just pointed it out? Where is it?
My lord, page 36.
Yes.
We start from
noted.
30.
Yet there is nothing that has been brought to the notice of this court to substantiate the aforesaid. As such, this writ petition stands disposed of by providing that the respondents shall consider the case of the petitioner along with other eligible departmental candidates who come within the zone of consideration for promotion to the next higher rank in accordance with the requirements of the rules as and when such exercise is initiated. Writ petition stands closed.
Item 7.
My lord, I am appearing on behalf of my senior Mr. B.K. Singh. My lord, he is on bereavement due to death of his father-in-law. So my lord, matter may be taken up after vacation.
Mr. Edward Gupta, and a senior counsel.
My injury order, Mekan.
Petitioner, a prayer for adjournment has been made on behalf of the respondents by stating that the learned standing council FCI has suffered a bereavement. In view of the reason cited above, seeking adjournment, the prayer stands allowed. Let this matter be listed again in the first week of August 2023. Interim order passed earlier.
Interim order shall continue.
Nice.
Item 8.
Yes, Abhilash. Well, this matter is relating to compassionate appointment. My claim was placed before the DLC. But DLC, my lord, certain document, there was certain deficiency of document, and matter was lordship remanded to the chief executive officer to bring those relevant information losses. That was not placed. That's why lordship, my claim of the petitioner was not considered. Case lordship 26, the DLC recommendation.
Yes, we'll close it then.
My lordship, may kindly have a look our affidavit. We have filed affidavit page 38, my lord, running page. Paragraph 7 and 8.
Yes.
After that, lordship, they have.
May I
already-
Paragraph 7, my lord, that with regard to the statement made under the paragraph 7 of the petition, the deponent begs to state that as per the proposal forwarded submitted by the chief executive officer, Jila Purikar Karimganj, while later dated so and so, the application of the petitioner was placed before a DLC held on 28/2/2019 for consideration. The DLC, after examining the claim, has found that certain essential information are required for taking decision thereof, and accordingly, the DLC has requested the CEO to furnish the particulars, keeping in conformity with the government OM dated so and so for placing the claim before the next meeting of the DLC. Then 8, my lord, that is regard to the statement made under so and so, the deponent begs to state that as per record, the DLC has not received any further information.
So why the
proposal.
CEO has not given the information?
My lord,
I have instruction, my lord, by Indian DLC, they will submitting mails.
my lord, already that's a document lordship, CEO has already furnished that information after filing this requisition. I have given that.
Then we will place before the next available DLC, my lord. Lordship may dispose of the matter.
Mr. M. Khan, counsel for the petitioner, also heard Ms. M.D. Bora, learned government advocate Assam, appearing for respond numbers
2 and 4, my lord.
2 and 4.
And for 1, 3 and 5.
As Dr. Leonard, standing counsel, Panchayat and Rural Development Department, Assam, is present on behalf of respond numbers
1, 3 and 5.
3 and 5. The case of the petitioner, in a nutshell, is that her father was an employee under the Panchayat and Rural Development Department, while serving as the secretary of the Bazarghat Gaon Panchayat. The petitioner's father died in harness on 25/6/2016. Having lost the sole breadwinner of the family, the writ petitioner, being the daughter of the deceased government employee and being eligible for seeking a government job, had submitted an application on 23/8/2016 praying for appointment on compassionate ground. full stop. The application of the petitioner was considered by the district level committee bracket DLC bracket close of Karimganj in its meeting held on 28/2/2019, whereafter it was found that certain relevant informations pertaining to the petitioner's candidature were not furnished by the respondent number 5. As such, those additional informations had been called for from the respondent number 5. First up. However, since there was delay on the part of the respondent number 5 in furnishing the information as called for by the DLC, thereby resulting in further delay in consideration of the petitioner's case, the instant writ petition has been filed seeking a writ of mandamus. It appears that during the pendency of this writ petition, the respondent number 5 has furnished the requisite information to the DLC. The aforesaid fact is evident from the communication dated 01/04/2023 issued by the respondent number 5 to the respondent number to the Deputy Commissioner Karimganj, which has been produced by the, who has produced this? Petitioner's Council. Mr. S. Datta has also confirmed the said position. In view of the above, nothing survives for decision in the writ petition. So the writ petition is therefore disposed of by providing that the DLC will consider the case of the petitioner in its next meeting and take a decision as to the application submitted by her seeking compassionate appointment by taking note of the standing government circulars, notification and court orders relevant in the matter. Facilitating the above, the petitioner to produce a certified copy of this order before the authorities within a week from today.
I'm before this, my lord.
May it please your lordship. Lordship, to this present writ petition, I have challenged the extension of the suspension order, which is at page now 106. The original suspension order is at page now 104, which is dated 1st of November 2022. And the extension order is 3rd February 2023. The lordship, otherwise the issue is otherwise settled with regards to the Deepak Mali judgment that review has to be done prior to the expiry of the 90 days period as mandated in rule 10 rule 7 of the CCA rules. Now the only question which is left for your lordships to decide is the effective date of that particular suspension order. As to when does that date of suspension order runs? When does the 90-day period start? So to that effect, your lordship, the petitioner stand is basically it runs from the date of issuance of the suspension order, which is 1st of November 2022. And the stand that they have taken, the respondents have taken, is that it runs from the date when it was actually served upon the petitioner, which is 7th of November. So they are taking the stand that since it was received on 7th of November, it would run till 5th.
Just a minute. What has happened? How many petitioners are there in these two cases?
Same petitioner.
In item 9, what is the issue?
He has challenged the extension of the suspension order. And item number 10,
He was placed under suspension when?
On 1st of November 2022. It's at page number 104. If I may just take your lordship.
1 minute, please. Please first give the information I want. After that. Page 104, the first order of suspension. Departmental proceeding has been initiated against him.
Initiated in the meantime.
All right. Now, this order has been extended.
Extended.
How many times?
Only once.
When was the date of extension?
3rd February 2023. Which is at page now 106.
Right. Then what is the second writ petition about?
Second petition is I have filed it in 2022. I challenged the original suspension order dated 1st November 2022.
Then what have you challenged in the first writ petition?
Item number 9, I have challenged the extension, 3rd February. That 3rd February 2022.
In item 10, the order dated 1/11/22 is under challenge, and in the next matter, 3/2/2023.
Yes, Your Lordship.
All right. So your client is still under suspension and
Under
the departmental proceeding is going on.
Moving on.
Now, your case is that the order ought to have been reviewed prior to expiry of 3 months,
Yes, Your Lordship.
as per the Deepak Mali judgment.
Deepak Mali judgment.
But here they have done it
After 90 days.
after 90 days, but prior to expiry of 3 months from the date of service of the order of extension on your client.
It is that their case.
This is their case.
Their case.
According to them, it should be 90 days prior to service of order of extension.
Yes.
According to you, it should be 90 days prior to expiry of the original tenure
Original
of
suspension.
suspension order. Is there any decided case law on that?
Yes, Your
Which
Lordship.
is the judgment?
Your Lordship, with regards to this issue of effective communication, date of effective communication, I have placed one judgment. It's a 4-bench judgment of the Honorable Supreme Court as to when that particular suspension order could be said to be valid, would be said to be effective. If Your Lordship goes to paragraph number 17 of the judgment, I've taken the liberty, 14th line. I've taken liberty to mark that 14th line for Your Lordship's consideration. It starts with question mark. It will be seen that in all the decisions cited before us, it was the communication of the impugn order which was held to be essential and not its actual receipt by the officer concerned. And such communication was held to be necessary because till the order is issued and actually sent to the person concerned, the authority making such order would be in a position to change his mind and modify it if thought fit. But once such an order is sent out, it goes out of the control of such an authority, and therefore there would be no chance whatsoever of his changing his mind or modifying it. In our view, once an order is issued and it is sent out to the concerned government servant, it must be held to have been communicated to him, no matter when he actually received it. We find it difficult to persuade ourselves to accept the view that it is only from the date of the actual receipt by him that the order becomes effective. If that be the true meaning of communication, it would be possible for a government servant to effectively thwart an order by avoiding receipt of it.
So now that has to be, that law has to be settled by this court.
Yes, Your Lordship.
That cannot be done before vacation. Choose a date. We can't now go into these hearings and write judgments before vacation. If the law has to be settled on that, then.
Yes, madam. Immediately after vacation, madam. 20 July, madam.
Your Lordship, otherwise, Your Lordship,
Yes,
as Your Lordship deems fit.
You argue, but then we'll again fix it after vacation.
I understand, I understand,
Now there is no time.
I understand.
I am personally traveling to outlying bench.
Yes, ma'am.
So there is no time to hear and deliver judgments.
Immediately after vacation. madam.
Immediately after vacation, Your Lordship.
20 July, if it's possible, madam.
Why 28th July? Let's do it on
As your lordship,
16th
as-
July only, at night.
as your lordship
Huh?
think.
Let us do it on 16th July around evening, late evening.
As your lordship, madam. August.
Why have you extended his order of suspension? What is the allegation?
My lord, there is in Bhutan, my lord, there is a project, my lord. There is huge corruption, my lord, and there is completely corruption also, my lord. The party concerned to whom it was given the contract, my lord, they were when inquired such, they have no such
What
existence.
is the stage of the inquiry department?
The inquiry officer already appointed, my lord, and my lord, they have also replied, my lord, so also replied, my lord, and my lord.
You give us a status of the.
Yes, madam.
department
Yes,
proceeding on the next date.
Yes, ma'am.
Heard Mr. D. Bora, learned counsel appearing for the petitioner in both these cases. Also heard Mr. S. K. Medhi, learned CGC representing the official respondents. Who else is there?
My lord.
In item 10 and for respondent 7.
Mr. A. Todi, learned counsel is appeared for respondent number 7 in item 10. Miss
On behalf of R.K. Talukdar for NHIDCL.
National Highway Authority, my lord. She is from for National Highway.
D. Deca.
D. Reka.
D. Deca, learned council is present on behalf of the NHIDC. First up, the core issue involved in both these writ petitions is pertaining to the question as to whether the review of the order of suspension is required to be made prior to expiry of 90 days from the date on which the order of suspension was issued, or whether the period of 90 days should be computed with regard to the date on which the order of extension of suspension is communicated to the employee. Yes, first up. Learned counsel for both the sides have submitted that the aforesaid issue has not been settled in any previous decision of the court, and therefore the matter would require elaborate hearing, which would not be possible immediately before the summer vacation. As such, on the request of learned counsel for both the sides, registry to list this case again on 25th of July 2023 as list these matters as fixed items for admission hearing. On the next date fixed, the learned CGC to also obtain written instruction and appraise this court as to the stage of the departmental proceeding initiated against the petitioner by projecting the tentative time period within which the same is likely to be concluded.
Well, instead of 25th, 2nd of August, my lord.
Your lordship, already
My lord, actually, I'll be out of station, my lord, 20.
Out of station where? Going for a holiday?
No, my lord, idle bench, my lord.
Idle bench.
Yes,
How long?
My lord,
Then we'll have it the previous week. 20th of July.
20.
20th of July, yes. Highly obliged. Your Lordship.
High level.
Lordship, in this matter, today only we have filed the affidavit, Lordship, on behalf of the respondent number 4, Lordship, and this is not in record, Lord.
Mr. S.K. Das, learned counsel for the petitioner submits that a copy of the affidavit in opposition filed on behalf of the respondent number 4 has been served upon him only this morning. Therefore, 3 days time be granted to seek instruction. Ms. M. Bhattacharjee, learned counsel, is present on behalf of the respondent number 4. First up, on the request of the petitioner's counsel, this matter is directed to be posted again on 27th of June 2023 as a fixed item. By taking the affidavit with the record.
27 days.
Yes, Mr. Chakraborty.
My lord, here this is a case. On the other day, my friend brought the record, the case for promotion.
I have the record minutes and the.
My lord, this man is retiring on 30th of this moment.
Hmm.
And my lord, on 1st of April, others were promoted, though he was in the zone of consideration. And the advertisement specified 11 vacancies, and the mode of promotion was by way. Lordship will have a look at the advertisement. Page 16.
Page 16.
Promotion on the basis of marks scored in the interview and.
So this matter will take some time. We'll hear it today at 2. At 2. Orders, you call for orders.
For order, item 13 and 19.
This is a matter where the candidates are waiting for their results of an recruitment process initiated in 2019. I am for declaration of results. The others were in some litigation, wherein the petitioners have been protected by keeping vacant posts.
My lord, we were also participants there. We are having civil engineering with civil engineering and planning. Whereas my lord, the qualification given is civil engineering. Whether these are same or not, that is what is to be known. AICT has already declared that this is same, my lord. But my lord, they are not that. That's why the honorable court wanted to hear the matter, and my lord, this protection was given to us that that much number of posts would be kept vacant.
How many petitioners in total?
In total.
Item number 13, Lordship, we have 33 petitioners. In item number 13, in item number 15, Lordship.
My lord, item number 14, we have 11 petitioners.
11 petitioners.
And total number of vacancies?
Lordship.
Total posts?
Lordship, in
No,
item
post,
number
post, my lord,
307, Lordship.
307, madam.
Initial 344.
Lordship,
Initially,
in item number 16, there are 33 posts, and in item number 18, 30 posts.
Posts of petitioners.
Petitioner.
Like this post were already being.
So my lord may have this matter for admission hearing, my lord, if not otherwise inconvenient, my lord, and on that day, if my lord can hear the matters and brush it off, my lord.
Lordship, item 19 has been recently filed. So in this case, we have received instruction. We will file a short affidavit in this case, Lordship.
Item 19.
19, Lordship.
And why don't you declare the results?
Lordship, there is a so many Lordship litigation is going on, Lordship. In this case, all are clubbed together. There are total 95 posts has been 92 posts has been directed to be kept vacant. That issue, without deciding that issue, if I declare the result, there in any way, Lordship, there would be prejudice of both the side, Lordship, as well as the employer, as well as the candidate also. If Lordship can direct us to declare the result, we can declare, Lordship. But their post must be earmarked, Lordship. Out of 307 posts, if we have to keep 92 posts, that post has to be earmarked by the department.
So what order is?
My lord, if lordship can have it immediately on reopening, say a few days after reopening for admission hearing. In the meantime, my lord, if there is some pleading done, let them do it. My lord will consider the matter and finish it up. My lord. It not take much time. My lord.
All right, you take down her learned counsel for the respective petitioners. Counsel for the petitioners appearing in the respective read petitions. Full stop. These petitions raises a common issue of eligibility of the petitioners to participate in the selection process for filling up the post of
junior engineer,
Junior engineer civil.
junior
PWD.
engineer civil in the PWD Assam. First up, according to the petitioners, since the APSC has conducted the selection process, the results be declared. First up, Mr. Datta, PB Datta, learned standing counsel APSC on the other hand submits that he has received instructions in connection with item 19 and therefore be permitted 2 weeks time to file affidavit. Since the issues involved in this writ petition are of complex nature, this court may consider passing appropriate orders only after the affidavit on behalf of the APSC is brought on record in item 19. Similar is the submission, you are for? Similar is the submission of learned counsel for the other respondents appearing in this case.
For
In
respondent
view of the above, and on the,
2, 5 and 6.
in which case?
Item number 19.
90, fine.
In item 19, similar is the stand of so and so in item 19. In view of the request made at the bar, let these writ petitions be listed again on 26th of July 2023 as fixed items. Counter affidavit on behalf of the APSC be filed on or before 24th of July by serving advice copy upon the petitioner's counsel. So, next hearings will start from two. Orders.
By which applications were sought for the promotion from scale 3 to scale 4. What you will see at serial number 2, number of vacancies 11.
Page 12.
Yes, 16, madam. I'm sorry, madam. 16.
What is this?
This is a letter issued for promotion of officers from scale 3 to scale 4. And the promotion should be on the basis of marks scored in interview and performance appraisal of individual officers. Serial number 2, my lord, vacancies 11. Eligibility, officers who have completed 4 years of uninterrupted service in MMG scale 3. And the reckoning of the minimum eligibility, that is on 1st of April 2023. And marks given
What is
in
the issue?
issue, my lord, 11 posts were advertised. I applied, only 5 persons were promoted. I was not promoted. I wanted to know the reason why. They have not given me any reply. I wanted to have my ACL and the minutes of the selection committee not given. So, my lord, the basic question is they have advertised 11 vacancies. 5 persons were appointed. Now, my lord, there is no minimum qualifying marks prescribed.
So what is the reason why you have not promoted?
I have the selection record, the tabulation of marks, as far as the criteria was twofold. One is that the last 4 years performance, appraisal reports were examined. Those were prepared by the HR department, forwarded to the selection committee. Then separately, there was a interview in which the marks were 40 in number. So 60 marks for the appraisal in the last 4 years, 40 marks for the interview, total 100 marks. There were 9 candidates, and as per my instruction, the petitioner was at 7th position. So only 5 candidates have been selected. Serial number 6, 7, 8, 9. 6, 8, and 9, they have not challenged the proceeding till now.
But if there are 11 vacancies and he was in serial number
the
7.
committee did not think it proper, my lord, that the others, only the 5 top.
But
I have the
why?
tabulation, my lord.
Why? Why?
But as such, no specific reason has been there. For that, I'll have to file an affidavit, my lords. But I have the tabulation that
My lord,
can go through.
my instruction, because
Mr. Chakravarti, please take your seat.
Yeah.
No, you set the rules,
Lordships.
method, mechanism prior to
Lordship.
process.
Lordship.
11 posts.
11 posts.
The petitioner fulfills the eligibility condition.
My lords, he does, but there is one aspect of the matter.
Will
my
you
lords.
please listen to what I'm
Lordship.
saying? He fulfills the eligibility condition.
Yes.
He participates and is one of the 9 who had participated.
Yes.
And his rank in order of marks scored and ACR evaluation appraisal,
Yes.
etc. He stands at serial number 7.
7. Yes.
You suddenly draw a line that below 5 you will not promote.
Lordship.
Why? What is this decision is based on which decision prior to the?
Lords, for that, the tabulation has to be seen. I'm not privy to that. That is in a seal envelope. I can forward it to your lordship. And my
We'll
lord,
dispose of this matter today.
then my lord, it at page number 16, which my learned friend has read, it was specifically stated that the bank does reserve the right to reduce the number of vacancies in case there is a shortfall in candidates found suitable for promotion.
So suitability criteria has to be pre-decided. You can't decide it after holding the.
That is there,
That's
my
the
lord,
law.
but the aspect of the matter is that the petitioner fully knew that there was no such cutoff mark or there was no such eligibility as such.
So,
and therefore,
so you can say that by virtue of this decision taken prior to
yes,
the DPC mat,
lordship.
the XYZ doesn't come in. Otherwise, this can be used as a weapon to discriminate, which is what he's alleging. How does the court deny him the relief?
My lord, the marks tabulation may be seen. After that, my lord,
Marks is his number 7.
yeah, he's number 7.
That's fine.
And
he's
above him,
accepted.
there is 6 also. 6
That's
has not
fine.
also been selected. 8, 9 also not selected.
So what
Only the
happens
top
to 6, we are not concerned.
Lordship.
The 7th has come to the court. On
Yes.
what basis the court will deny him the relief?
My lord, it's a my lord, the marks tabulation. My lord,
This whole exercise is arbitrary. That's what he's saying.
No, the-
Non-transparent.
non-transparent, but he was fully aware of the features of the
yes,
of the
yes.
promotion.
When was the decision taken to promote 5?
my lord, the promotion order was issued on
Which
first
page?
of,
Which page?
my lord,
Page 20. my lord.
20. This is the promotion order. Promoted with effect from 1st of April 2023. It was uploaded on 31st of March. And I have provided, my lord, a copy of the service rule. Yeah, my lord, the selection is on the basis of marks. There is no cutoff marks in the service rules also, my lord. Lordship may come to page 11 of the rules. Serial number 4, this is officers scale 4,
When is he due to retirement?
30th of June. Lordship
Is there
will,
any adverse entry in his SCR?
Lord, he has been allotted a certain number of marks. As I said, my lord, that is, the tabulation is in a sealed envelope. My lordship will have to go through that. My lord, the
last 4 years appraisal was prepared by the HR department, forwarded to the selection committee.
That's correct, but you have not set any cutoff mark.
No, there is no, because in the rules, there is no such cutoff mark provision at all.
Yeah.
So that certain amount of latitude, my lord, is there to the selection committee to.
That you have to decide prior to the, you have everything, but
I do
it has
understand
to
what your
be
lordship-
pre-decided. You cannot change the goalpost after holding the
But
meeting.
my lord,
That is the
in this
principle
case,
on
my
which
lord,
a mandamus
the
will be
rules do
issued
not-
to promote him.
lordship, my lord, the.
Let this arbitrariness not prolong too far, Mr. Ganguly.
So for the other posts are concerned, up to scale 3, there is a cutoff mark in the rules.
All right, I had Mr. S. Chakraborty, learned counsel appearing for the writ petitioner, also had Mr. A. Ganguly, learned counsel appearing for the respondents. The writ petitioner hearing is an officer serving under the Assam Gramin Vikas Bank, who is presently posted as, what is his posting now?
My lord, senior, scale 3 post, my lord. Scale 3 officer.
In a scale, who is presently holding a MMG scale 3, Roman 3 post in the bank. Full stop. According to the petitioner, he is due for promotion to the next higher grade, that is MMG scale Roman 4, capital Roman 4. Full stop. Although he had participated in the selection process for promotion to the next higher grade, the respondents have not promoted him. First of Mr. Chakraborty submits that there is no reason cited by the respondents for not promoting his client. As such, the present writ petition has been filed. First up, after taking note of the grievance expressed by the petitioner, this court had issued notice on the bank asking them to show cause in the matter. Full stop. On receipt of notice, Mr. Ganguly has appeared for the respondents. Full stop. Today, when the matter is called up, records of the selection procedure has been produced. Full stop. Next para. It appears from the record that on 12/10/2022, the bank had issued a notification notifying the intention of the bank to consider officers in the MMG scale 3 for promotion to 11 vacant posts in the grade of MMG grade 4. Full stop. Petitioner was one of the 9 applicants who had participated, one of the 9 officers who took part in the selection process. Full stop. The promotion is to be given on the basis of marks scored in the interview and performance appraisal of individual officers. Full stop. By applying the aforesaid criteria, the petitioner's name appeared at serial number 7 in order of merit. However, by the notification dated 1/4/2023, the respondents have promoted only 5 officers in order of merit. Full stop. Mr. Chakraborty submits that 5 officers in order of merit by leaving aside the petitioner and 3 other officers who had participated in the aforesaid process. Full stop. Mr. Chakraborty submits that his client is due for retirement on attaining the age of superannuation with effect from 30/6/2023. Full stop. Notwithstanding the fact that he had participated in the process for selection of candidates for promotion to MMG scale 4, and despite the fact that the regional rural banks bracket appointment of officers and employees bracket close rules 2017, comma, applicable in the present case, comma, does not provide for any cutoff mark for promoting officers from MMG scale 3 to MMG scale 4. The respondents have arbitrarily denied promotion to the petitioner. Full stop. hence this writ petition, so as such, a writ of mandamus has been prayed for by the petitioner, directing the respondents to promote him to the level of MMG scale 4, full stop. Mr. Ganguly, on the other hand, has fairly admitted that there was no cutoff mark fixed by the selection committee for considering the cases of officers for promotion to MMG scale 4, full stop. He, however, submits that the 5 officers who were promoted rank higher than the petitioner, and the officer 6th in order of merit did not challenge the selection process. As such, no relief can be granted to the petitioner in this case. So I have considered the submissions advanced at the bar and have gone through the materials available on record. Full stop. There is no dispute about the fact that the writ petitioner herein is serving in a MMG scale 3 post and is eligible for being considered for promotion to the next higher grade, that is MMG scale 4. Full stop. It is also not in dispute that the petitioner had participated in the selection process and had emerged as the 7th candidate in order of merit. Full stop. Out of the 9 candidates who had participated, serial numbers, the candidates who had emerged in serial numbers 1 to 5 have already been promoted. Full stop. Records produced by Mr. Ganguly reveals that there was no cutoff mark fixed for consideration of the candidatures of candidates who had appeared before the selection board. For there was a selection board, is it?
Yes.
Selection board for promotion to MMG scale 4. Full stop. As a matter of fact, the rules of 2017 do not permit fixation of any such cutoff mark for promotion from scale MMG scale 3 to MMG scale 4. A careful examination of the departmental records go to show that the selection board had not fixed any criteria based on which candidates scoring marks below a particular level could be denied the benefit of promotion. If that be so, the above action on the part of the respondents in denying promotion to the petitioner hearing without applying any transparent and reasonable criteria on the face of the record appears to be arbitrary. Full stop. If the petitioner is due for retirement with effect from 30/6/2023, then it is also apparent that he would not have the opportunity of being promoted to MMG scale 4 ever again during his service career. Full stop. Under the circumstances, this court is of the opinion that the petitioner has succeeded in making out a good case for interference by this court, where a writ of mandamus can be issued to the respondents. Full stop. As such, this writ petition succeeds and is hereby allowed. The respondent numbers 1 to 3 are hereby directed to give effect to the select list prepared by the selection board based on participation of the petitioner, and therefore and thereafter issue order of promotion in favor of the petitioner, promoting him to MMG scale 4 rank. Full stop. The aforesaid exercise be carried out and completed with effect from within a period of 2 weeks from the date of receipt of a certified copy of this order. With the above observation, writ petition stands disposed of. The records be returned back to Mr. Ganguly.
Promotion with effect from 1/4/23 when the others were also promoted.
Giving effect to such promotion. No, others means what? They were all senior to you.
No, in the feeder post, they were junior to me. And in the rules, as per the rules, when they are promoted, they carry their.
With effect from the date on which his juniors had been promoted to MMG scale 4 rank. Yes.
For hearing items 20.
Made legal officer. Lordship, the matter was heard, my lord. And on the last occasion, we pointed out that, my lord, total 80 officials were appointed as agricultural development. 20 to 21. 20.
Yes, what do you have to say?
Yes, my lord, out of total 80, 36 incumbents were, my lord, accused in, my lord, special case now 5 of 2021.
So who is
That
appearing for the?
Only, my lord, the petitioner has been discharged from service, and since 31/12/2021, he is not getting anything, my lord. Rest had-
Which is, who is there in item 20?
I'm there. Pardon me.
What is this matter?
I'm sorry, madam, I is item 21. Sorry.
What is this case about?
This is disciplinary proceeding. Challenge
We'll
is,
hear it today, but also tell me a date after vacation when we can pose the matter. It is not possible to deliver judgment in these matters or conclude the hearing today.
all that I want to make clear is on the last occasion, we had to face the client. Lordship will pass the order in such a way. Because of the paucity of time, Lordship is fixing another date. And it's not we who is asking.
All right,
for
then
it.
you argue, we'll hear the matter. Yes.
No, but I have no difficulty.
No, that's all right. Then we'll hear. Then we'll see. As long as it goes, we'll see. Who is appearing in item 21? Item 21. For the respondents?
Yes, Lordship.
Under.
Item 21. 21.
Just a minute, yes.
Yes. 21, Lordship, here in this case, Lordship, we submitted our written argument, Lordship. At the same time, with the petitioner.
All right, then you don't know about it. We'll take it up later. You are supposed to come back with your response. Do you have it or not?
Yes, Lordship, but we need some time, Lordship.
Say that.
Yeah, let's.
Why are you saying we submitted written statement, they filed writ petitions? We don't need to get in. We'll fix it after vacation then.
Lordship.
All right, heard Mr. J. Patwari, learned counsel appearing for the writ petition. Item 21. Mr. J. K. Goswami, learned government advocate, Assam submits that some more time is required by the state to come back with the replies to the query, to the issue raised by this court, by the order dated. Give me the file, please. Order dated. Order dated 5/6/2023. In view of the request made by the state, which is not objected to by petitioner's counsel, registry to list this matter again on 27th of July 2023 as a fixed item. Yes. What about the other cases? Today, other cases will be difficult. Can wait. Huh?
Item 23 is a very small matter, Lordship. Lordship can dispose of because the department has not granted the family pension of the petitioner to his mother. Only on the grant that she is earning salary more than the minimum basic pay.
How much time will you need? How much?
15 minutes, Lordship.
15 minutes, then you have to wait. 15 minutes is a long time, which means 30 minutes. Yes.
My matter is otherwise small. I am on a very small issue. The disciplinary authority, my lord, the inquiry officer has held some of the charges proved, the rest were not proved. The disciplinary authority then issued me, as per the requirement of law, my lord, issued me a notice saying that tentatively we are holding that all the charges are proved. And then I was given the opportunity to file representation. I filed a representation. Thereafter, my lord, Supreme Court says that you have to finally hold that the charges are proved. That is not there. Straightway there was a penalty, my lord. So on that ground, the penalty will go in. And I was reading the judgment of, my lord, Punjab
Just a minute,
National.
just a minute. I'll bring it out.
My lord, I have given handed over copies of the judgments on which I. On this score itself, my lord, the penalty will go. This is 1998 7 SSC page 84. My lord, Lordship may straight go to page 19, where para 19, my lord.
Just a minute, Mr. Rajendra, please take your seat. কোন পয়েন্টে বলছো? কোন পয়েন্টে?
আপনার এনকোয়ারি বলেন।
What is the penalty?
Penalty, my lord, lordship will find reduction to a lower stage in the time scale of pay by 4 stages for 4 years, and he will not earn increment for this 4 years. Plus, on the expiry of the period of this period, reduction will have effect of postponing future increments. It's a major punishment under their rules, my lord.
So
Well-
where is the order of penalty? Let us see.
My lord, penalty, your lordship will find at page 83, my lord.
Okay, yes.
83. Page 85, the last paragraph is the upper department. Page 85. The last paragraph, you know. Reduction to a lower stage in the time scale of pay by 4 stages for a period of 4 years, with further directions that the officer will not earn increments to pay during the period of such of reduction. And on expiry of such period, the reduction will have the effect of postponing the future increments of his pay in terms of rule number 67F of the SBI OSR.
Appellate authorities rejected the appeal.
Yes. Mechanically, they have rejected. The appellate authorities finding is simply that no new convincing fact has been brought in, so I'm rejecting. Well, I'm on basically 3 points. Number one is, my lord, the enquiry officer did not hold all the charges to be proved.
Yes.
The disciplinary authority differed with the findings of the enquiry officer. Accordingly, I was given notice and an opportunity to make representation. That much is all right. After I filed a representation, it was incumbent on the disciplinary authority to ultimately hold that all the charges are proved.
No, the disciplinary authority held that only one charge was proved.
Disciplinary authority. No, man. I'm again repeating. Enquiry officer has, out of 8 charges, my lord, held that around 5 charges or 4 charges proved, remaining are not proved. Then disciplinary authority gave me a notice that they are going to differ with the findings of the enquiry officer and asked me to file a representation. I filed my representation. Now, after I file my representation, considering my representation, either they reject my representation or they allow, they have to hold that all the charges are now proved and we are rejecting your representation. And then the question of imposing the penalty will come. This is what the Honorable Supreme Court is saying.
Yeah, which judgment?
My lord, 1997, I'm sorry, 1998, 7 SCC,
Punjab National Bank.
page 84. I've given a copy, man.
Yes, para 19.
I'm straightway reading the paragraph which is relevant for this submission, my lord. Para 19, page 97, my lord. The result of the aforesaid discussion would be that the principles of natural justice have to be read into regulation 7.2. This much is okay, my lord. As a result thereof, whenever the disciplinary authority disagrees with the enquiry authority on any article of charge, then before it records its own findings on such charge, it must record its tentative reasons for such disagreement and give to the delinquent officer an opportunity to represent before it records its findings. The report of the enquiry officer containing its findings will have to be conveyed and delinquent officer will have an opportunity to persuade the disciplinary authority to accept the favorable conclusion of enquiry officer. The principles of natural justice, as we have already observed, require the authority which has to take a final decision and can impose a penalty to give an opportunity to the officer charged of misconduct to file a representation before the disciplinary authority, records its finding on the charges framed against the officer. Now I'll show you, Lordship, how things have proceeded.
Where is the notice of disagreement?
My lord, that your Lordship will find at page 66, my lord. 66. Page 66, my lord. Lordship will kindly see allegation number 1. Charge number 1 was held to be not proved. Charge number 2 was held to be proved. Then charge number 3 was held to be not proved. Charge number 4 also was held to be not proved. 5 was held to be proved. 6 was again held to be not proved. Then 7 also not proved. 8 proved. So out of this 8, my lord, 1, 2, 3, 4, 5 charges were held to be not proved. So my lord, page 67, lordship will find the second last paragraph. It says,
So out of 8 charges, charge number 2 is proved,
my lord,
5 is proved,
my lord, and 8,
and 8 is proved. 3 are proved.
my lord. Now, my lord, this page 67, lordship will kindly see the second last paragraph. It says, if you desire, you may return your representation stroke submission within 7 days from the date of receipt of this letter and inquiry report come findings. Please note that no extension of time is permissible in this regard. Now, thereafter, I submit my representation, which is available at page 69, my lord. In
So
against,
that they have given you a notice of disagreement with
Absolutely.
reasons.
absolutely.
Yes.
This
then-
is a tentative view that we are going to differ. These are the reasons on which we are going to differ. Now, after I file my representation, after considering my representation, Honorable Supreme Court says you have to record your own finding that we are rejecting your representation. We are holding that the charges are proved.
Where is that decision?
My lord, this which I read just now, para 19. They have to record a finding. They have not recorded. Para 19 says, I'm reading from second line towards the end, my lord. As a result thereof, whenever the disciplinary authority disagrees with the inquiry authority on any article of charge, then before it records its own findings on such charge, it must record its tentative reasons. Well, the base 66 are the tentative reasons for such disagreement and give to the delinquent officer an opportunity to represent before it records his finding. That opportunity is also given to me. Now, after that, they have to record their own finding that no, we are now holding that all the charges are proved. That is not
So
there.
what you are saying is, after you submitted your report, they
No,
straight away issued the order.
Straightway
of
this
penalty.
is the part. And unfortunately, my lord, in the penalty which is available at page 83, lordship will also find at page 83, they have mentioned that I submitted my representation. Page 83, my lord. First line says we refer to our letter, that is 17/3/2011, that is the disagreement notice, and your written statement of defense dated 12/4/2011 thereto, and enclose a copy of the order in duplicate dated 22/8/2011 passed by the appointing authority and general manager in respect of the above case. In this connection, if you desire to make an appeal to the appellate authority against this order, you may do so. Then this order of penalty. Where is the compliance with the direction of the law later?
So assuming your argument is accepted,
My-
order of penalty is set aside.
My lord.
They will again give you a hearing and pass a fresh order.
Absolutely. So far as this point which I am raising is concerned, this should be the order as the lordship is saying. Well, it is correct. But I have got two other issues where my submission will be possibly it cannot go back. Second is, my lord, after the there is a small issue that along with the inquiry, my lord, charge sheet, they have to give this list of witnesses, etc. They have not given me. There I was prejudiced. Anyway, my lord, that is also a small issue. Other than this, my lord, this is a case where the entire case is based on documents. All the charges can be said to be proved only if the documents in support of the charges are held to be proved. Now, the documents which are produced, not a single witness was examined to prove those documents, contents of the documents. They were simply marked and given to the inquiry officer, and he has proceeded with the recording.
So you are challenging the entire report whole hog.
My lord,
We'll hear it after vacation. Today not possible. You
because
said 10-15 minutes small issue.
my lord, lordship is correct. So far as the second point which I have urged first is concerned, if your lordship is accepting my submission, then it has to go back. But so far as this argument is concerned, my submission will be when there is no evidence. And this your lordship is aware that BC Chaturvedhi's case and all it says.
Well, then
If
we
it-
have to go through the entire.
If it is a case of no evidence, then possibly your lordship will not allow them to again.
So that you're right,
My lord.
but that will be a,
My lord.
we'll have to go deeper into the records. The problem is I'll be traveling from the
My
afternoon. And therefore, there are some judgment
Well, I'm not
cases
for a
already.
moment saying that you should or should take it up today, subject to the convenience of the court. I'm only making submission because
No, what I'm saying is matters which have already been heard.
yes,
I want to first clear up.
that will be, that will be a part of it.
We are facing the vacations next
Okay.
week. So in this period, a lengthy hearing and delivery of judgment will not be possible. So let us do it
I'll
after
have to go into
vacation.
the evidence and I'll have to go into
Yeah.
the,
See.
which document they have said to have been proved.
Okay. You have concluded his argument.
For posting a matter after vacation, yes, for that.
Your
purpose.
lordship may fix a date, not, all right. No.
Mr. D. Majumdar, learned senior counsel, assisted by Mr. S. Biswas, learned counsel appearing for the petitioner in this case, has addressed elaborate arguments assailing the legality and validity of the findings recorded by the inquiry officer, as well as the order of penalty to submit that it's the case of no evidence leading to issuance of the order of penalty. To stop. In order to appreciate the aforesaid argument, this court would be called upon to go through the LCR. You have the records today? You have
Yes,
the
ma'am.
records? Mr. Das Gupta, learned senior counsel, assisted by Ms. B. Das, appearing for the respondent bank, submits that let this matter be listed again after the summer vacation for conducting a detailed hearing of the lead petition. Taking note of the submission made at the bar, hearing of this matter stands adjourned till 8th of August 2023. List this case again for hearing as a fixed parted matter.
Well. 8 August. 8 August.
8 August. 8 August.
Tenth August.
Huh?
10th August.
10th August.
Who is the CGC here?
Mr. Chakravarti, Biplab Chakravarti was here.
He was here.
Since the morning, yes, when he was here.
What is this dismissal from service?
Dismissal, sir.
Mr. M. Datta, counsel for the petitioner, none is appeared for the respondents. Since the matter is posted for final hearing, this cannot be decided in the absence of the learned CBC. As such, registered to list this case again on 10th of August 2023 for hearing as a fixed.
Lordship, the petitioner is seeking family pension on the death of her son, who was working as a constable while in the CRPF. And after his death, she applied for family pension, and they rejected her case on the ground that the CCS pension rules, she is not eligible as part of CCS pension rules. But there is no such specific rule here in the CCS pension rules that debars the mother of the deceased government servant from claiming family pension just on the ground that she is dependent on the income of her husband. And moreover, we have stated in the petition that she is separated from her husband, and she is the husband and one son lives together, and she was dependent on the income of her deceased son. That is the only issue, and there is no rules, or even my learned friend, that is what there is no such rule in the CCS pension rules.
He died on duty.
Yes. Lordship, at page 30, 9, 10, 11, 12, page 12, the translated copy. The original is in English. Yes, he is in Hindi. Page 12. Annexure 3. Fourteen is the death certificate.
So what happens if a constable dies on duty? There is no scheme of family pension.
He is covered by the CCS pension rules. Yes, there is a family pension.
Which is
scheme
the
of the se-
provision? Which is, show me the provision.
Rule 54.
Rule?
Rule 54, that has been. Ekman Dioksa. This is the family pension scheme.
So he died within 1 year.
Yes. Lordship, that is not the
No,
issue.
no,
He's
Miss,
eligible.
Give me the
Oh, yes.
facts, otherwise I'll defer the matter.
I'm sorry.
I'm not going to pass an order merely because you want it.
No, I'm sorry.
I need to know what is the law, what is the rule.
Yes.
Hmm.
Lordship, he joined duty in the year 2010,
Which date? January or December?
28/12/2010.
Hmm. And he died on?
Died on Lordship 22/6/2012.
But in
The
your,
death certificate is at page 14 of the.
in your synopsis, you have written 18/6/2012.
It's death certificate says it's 22/6/2012. Death certificate.
But
at
you
page
say it is
14.
18/6/2012.
Lordship, the death certificate says it's to 22/6/2012.
Then it will be difficult.
Lordship, probably
You have
that is a
written
type of.
something else in your petition. You don't want to rely on that.
Lordship, that probably that is a typographical error in the synopsis.
Where is
Because the death
statement-
certificate
Where
at
is the
page,
statement about the date of his death in the petition?
at paragraph 3, paragraph 4, page 5. It is 18/6/2012.
Yes, and where is the date of that? That is what you have stated.
Yes.
What
but
is the death certificate?
But Lordship, the death certificate says it's 22/6/2012. Death certificate at page 14, Lordship. This is the type copy and the next page is the original death certificate photocopy. There it's 22/6/2012. Annexure 4. Bottom
The death
down.
certificate is correct. You are not reading it correctly. Death certificate also says he died on 18/6/2012.
I'm sorry, I'm looking at the date in the bottom, Lordship, the date of that, yes, 18/6/2012. I've made a confusion. I'm sorry. 18/6.
So he has served more than 1 year. All right.
Yes.
Huh?
Yes.
So what is your?
Lordship,
argument now?
eligibility is not an issue. They are not objecting to that, the fact that the mother who was dependent is eligible. Their only objection is on the ground that she is dependent on the income of her husband, who is a government servant. That is why she is not eligible for family pension. That the document.
Petitioner's husband is still working. She He's a government servant.
Yes.
In the affidavit. that was filed
Lordship, the
in
last page
2012.
of the petition, last page of the writ petition, page 20, annexure 8. Regarding sanction of dependent family pension. In connection with sanction of dependent family pension, it is to inform you that as per certificate furnished by you, your husband is in government job with annual income of 1,22,000. Hence, as per rule on the subject, you are not eligible for dependent family pension. So there is no such rule that if the wife who was dependent on the income of her son is dependent on the income of her husband, she is not eligible.
No, there must be some rule about who is entitled to receive family pension.
That is, Lordship, that is why their only objection is that she is dependent on the income of her husband, who is a government servant. There is no such.
What is the requirement of the rule for receipt of family pension?
Prior to Lordship 2012, in the as per the pension rules, rule 54(13)B said that if one is in receipt of some other pension, that person is not eligible to another family pension. But that rule has been omitted by the amendment of 2012. That book itself will reveal that even that disqualification has been removed.
See, there is no clarity. I can only dispose of the matter by asking them to give it a fresh look. Determination will not be possible. For that, you have to come up with what is the rule and address elaborate arguments on that. Are you ready to do it today? Merely by saying that rule has been amended, that will not do. You have to develop your argument then. Because there is no decided case on this.
No, Lordship, no, what we were relying on is that there is no specific bar in the statute. That was what my submission is. That is what my submission is. They say that
that submission will not.
Then Lordship, let it come up on another day.
There are no bar on many things. Does it mean writ of mandamus will lie? Writ of mandamus will lie only when you have an enforceable right. The fact that there is no bar on many things, it does not give you an enforceable right. You have to say that under these rules, which was holding the field at that point of time or now, I have a right to receive this pension. They are not giving it to me. They are denying it illegally. So issue a direction to give me the pension. You are saying what I am asking, nothing prohibits it. So give me your direction to give it to them. That order cannot be passed. That is not correct.
Lordship will then fix it on another date. There are no judgment as such. But there, as it is, they were in their affidavit, their only objection was that, and the sanction letter shows.
No. Their affidavit will not be the decisive factor here.
Lordship,
You have to stay on what this is, which provision of rule you are seeking the relief and convince the court, then we'll issue a direction. Just because there is nothing. There are many other things you can ask for because there is nothing else. Does it mean the court will grant it? That cannot be a legal argument.
Lordship, Rule 54, I was going through just now the amendment, it came to my notice. The book which I was relying on is
something which lays down who are the persons entitled to receive family pension.
Is under the family pension scheme, the Swami's book which I have handed over, it clearly says that the mother of the deceased government employee who was dependent on the income of the deceased son is entitled to family pension. It enumerates the categories of persons who are entitled to receive family pension.
So, the husband of the petitioner is a government servant, that you are not denying.
That we are not denying.
So why is it to be held that she is not dependent on her husband, but dependent on her son?
She is not living together with her husband. We have stated in our petition. She was living with her son. Yes, separated. The husband lives with one of his son, and she was living with the other son, who died. And even if she's dependent on the income of her husband, there is no bar under the rules that she'll be disqualified for that purpose.
No, there is a bar. You only say that somebody who is dependent only will get pension. If you get support from a wife is expected or is believed to be dependent on her earning husband. Unless the contrary is proved.
No, prior to the amendment of 2012, the rule 54B 13 stated that if one is, there was a disability clause, that if one is in receipt of some other pension, then that will be a disqualification. Even that has been omitted, meaning thereby that there is no such disqualification as such. Even rule 54 probably 10 says that if both the husband and the wife, if they are both are government servants, if one of them dies, then the other person will be entitled to family pension on the death of the spouse. Meaning thereby that even if the
I
husband,
understood, but this will require a detailed determination. This is not a matter can be,
then lordship,
This
yes,
will
yes, this will require some.
on
detail.
board judgment will not be possible in this. But you also have to come up with some authority. These are suggestions. These are not based on which ruling can be given of the court. You have to show where your right crystallizes. What are the facts? Yes, what were you saying? You wanted an early disposal of this matter. Why? Give her the pension. We'll record your statement.
But,
Pay her the pension.
no, if
Agreed.
Lordship gives that order, Lordship will pay, because yesterday, Lordship, I have gone so many judgment, Lordship, and all are in her favor. She is saying they are not, all are in her favor,
But she is not prepared with the judgment.
not in favor, that's why I have not brought it. And Lordship,
Lordship, I've gone through the rules, lordship, there is nothing in the rules. and
Just-
He says there are so many judgments in your favor, you have not brought it.
Lordship, then.
Either you ask him to bring
I
it for
thought
you.
that she would be able to establish a case.
Ms. D. Burgoyne and counsel for the petitioner seeks posting of this matter again after answering summer vacation in order to enable her to carry out more research on the legal issue arising for decision in this case. Mr. Sifai Burgoyne is present and does not have any objection if the prayer is allowed. In view of the above, let the petition be listed again in the first week of August 2023 for hearing.
That's what it is.
The lordship may fix another date.
After vacation. Obviously, it can't be before vacation. When? Which date?
My lord, 27 July.
No, 27 July, 40 cases are already there. You want to be 41st?
No,
No
it's a,
problem.
I would not,
You can enjoy the court's ambience for a whole day
at
till 4 o'clock and go home.
August 10th.
Any day before 15th August, your matter will not be heard.
So
16th August? You say it as motion and
16 is the, 16 is the motion.
16th is the motion.
Oh, that's all, no problem, found case.
Senior counsel is present on the petition. Mr. Mr.
SP Sharma.
SP Sharma, standing counsel APDCL. Praise for posting this matter for hearing again on 16th of August 2023. There are missed the case accordingly.
Departmental proceeding, but on a very narrow campus. There was an allegation against two constables. One is before your lordship, that they were found selling drug-like substance in my lord supermarket area and nearby Srinagar area. They were apprehended. And my lord, these things were recovered and then they were sent to jail. My lord, these things were also sent to the FSL. Now, they were bailed out. Thereafter, my lord, department proceedings started. In the departmental proceeding, my lord, the FSL report or the Caesar reports were never made a part of the list of documents. But finally, when the matter was, my lord, in the inquiry report stage, the inquiry officer, my lord, from through the IO, gets that report and he relies on that, saying that it has come out positive. So, allegation proved and they are dismissed. One of them is dismissed. The petitioner before my lord. Other one, nothing happened, my lord. He continued in service. Now, my lord, the trial takes place. In the criminal trial, this FSL report is placed along with the Caesar report, my lord. Caesar from me. Caesar report is, my lord, 0.60 mg and 0.90 mg. Original Caesar report. But what has gone to the, my lord, FSL is around 6.19 grams. So the court comes to the conclusion, what was sent to the FSL is not what was seized from me. So, my lord, that is not true. I was exonerated. So that FSL report, my lord, which was relied upon in the inquiry report as well as by the appellate officer and the discipline authority, is no report in the IF law, my lord. Because it does not establish the case. The drugs, it's not established. So, my lord, the penalty of dismissal imposed against this petitioner cannot be sustained. The other man, he is still continuing master. There was no proceeding against him. This is the limited, my lord, compass. Subject to what my friends would say. My lord.
Yes, what you would say? What you would like to say?
Olivia.
My lord,
090.
we have filed an affidavit, my lord. In this case, my lord, what happened, my lord? Earlier occasion also, my lord, record was called for. That was not found. That was missing. And the inquiry committee.
No records were called for because in the affidavit itself said the whole DAR proceeding is lost.
Oh, yes.
What was asked, my lord, that is already before your lordship.
No, my lord, otherwise, my lord, it is proved, my lord. They were dealing with the, my lord, drugs and they were, my lord, Caesar list is also there. That's why, my lord, the crime is, my lord, being a police officer, my lord, this crime is very heinous crime. Because they are the police. They should protect the public, my lord. Instead of them, they are doing this business, my lord. That's why, my lord, they are, my lord, dismisses, my lord, rightly dismiss them. So, my lord, they were during charge, my lord, body police team.
Let us
recovered-
fix it for hearing on 30th of June. Not ready?
After vacation.
No, it's good.
So and so list for hearing again after vacation.
They are satisfied. My lord, sir, my duty done, effort, they are
Yes, sir.
satisfied.
Give a date for hearing after
Lordship,
vacation.
After the vacation. Whenever it's convenient to the.
After vacation, we'll do it in all other matters.